are watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
Good morning and welcome to the Florida Supreme Court. The first case on the court's calendar this morning is Abdul versus State. Are the parties ready to proceed?
Yes, Your Honor.
You may proceed.
Good morning. May it please the court. My name is James Woolchack. Seated at table with me is co-counsel Megan Collins, and we're from the Public Defender's Office in Daytona Beach. We represent the appellant Dane Abdul in this direct appeal from his conviction for first-degree murder and the resultant sentence of death. We would like to focus this morning, because time's limited, on two of the issues in our brief. Issue number 2 regarding the opinion evidence of a police detective in the guilt phase of the trial, and issue number 7 regarding the propriety of the sentence of death. A brief statement of the facts regarding these issues.
Well, we've read all the briefs on that. Does the manner in which the issue of this police officer talking about this was not an accident, that kind of thing, does it change the dynamics or the chemistry of the law that's applicable? I mean, we certainly all know that police officers can't come in and testify as to the guilt or innocence of someone, but does it change it because of the filming of the interrogation.
Well, Your Honor,
where do we go with that?
We would submit that if this court were to affirm in this case, then the prosecution would be free, as the detective testified. This is a common interrogation tactic, to sympathize with the defendant, to tell him that you believe him and all that. And the state is saying it was necessary to show this to the jury, that he was just saying that to get the defendant to talk, and he really didn't believe that. But if this court were to affirm, then virtually every case where there's a confession where the police, detectives, or officers use this form of interrogation, it would open the door to allow the police officers to give their opinion regarding the ultimate issue here, the believability of the defendant or the defendant's actual guilt or innocence in this case. In this case, the sole issue at trial, the defendant admitted, having an argument with Ms. Sugdio, admitted pouring gasoline on her, admitted taping her with duct tape in an attempt to scare her to end the relationship. And so the sole issue was the intent of the defendant. Was he doing it just to scare her, or did he intentionally set fire to it?
We actually agree that there may have been some error, because, as you say, the issue here really was whether this was accidental or whether or not it was premeditated, correct? Right. And so if we agree with you that the officer should not have been allowed to make this statement, where does that get us? I mean, there is lots of evidence, I would submit, in this case that demonstrates premeditation. So in that statement, really, can we say that statement was really harmless in the scheme of things here?
I respectfully disagree with Your Honor on this. Yes, there was evidence that he intentionally purchased the gas can, the duct tape. He intentionally poured it on her. But I said the issue was whether he was just trying to
pour gasoline on someone. You have a fire and you put it on them, and that is not premeditation?
Well, the testimony never showed that he actually put it on her. His statement was that he lit the lighter after pouring it on her in order to scare her. His glove caught on fire. The Fire Marshal Juan Bailey, contrary to what the court's sentencing order says, agreed with the defense attorney that this scenario that the defendant had presented of pouring gasoline haphazardly, lighting it, catching a glove on fire, and then that, by going like this, could have ignited
and was it haphazard that he took the hose off of the fire can so that the gas can, and I assume that was so that you can throw the gas more freely as opposed to having to come out of the hose.
Again, it was intentional that he poured the gasoline on her, but there is nothing, even as I said, the fire marshal agreed that this defendant's scenario was entirely possible. He could not rule that out.
Well, let's go back to whether it was error, and that is to allow the detective to be questioned about stating whether he thought it was an accident or not. Mm-hmm. The way the tape read, could the defendant have argued that the detective thought it was an accident?
Perhaps, but the state then could have argued this is a technique that he was using, as you can see from it.
If the defendant had cross-examined the detective on that basis, would you agree at that point?
Yes. If the defendant had opened the door here, I would agree that he opened the door, he invited the comment on it. But here, it's the state's own evidence. The state chose to present this to the jury. They could have excised portions of the confession, but they chose not to. And by presenting this, they themselves were the ones that opened the door to their necessity of bringing out further opinion testimony.
And in the questioning, would it have been okay, in your view, could they have clarified to say, when you were saying to Mr. Abdul that it was an accident, why would you say that? And if they had just left it with, it was part of my interrogation technique, would that have been?
Perhaps that would have been better, but that's not the situation that we're here with.
Well, so it's it's the statement, Detective Gamble questioned him and said it was an accident. Did you believe it to be an accident at the time No, ma'am.
That is an opinion.
Just that one statement.
That is an opinion statement.
Did they use that then in closing? Did they rely on that in any way?
I do not believe that they belabored it, but the harm was already done. Case law shows that jurors tend to believe law enforcement officers more, and the case of Martinez and Tumblin and other cases
but
we
Martinez
cited.
I mean, in terms of what was said in Martinez, I know you're not going to agree that it's substantially more definite about saying that he was arrested because nobody had a doubt he was guilty is a fairly different type of opinion testimony. But you're not going to agree with that. But, I mean, I see that as qualitative.
Here we say it's the same thing, where he's saying, no, I don't believe it was an accident.
But he doesn't come out then, and I mean, again, in terms of assessing the harm, and then say, I saw it as intentional because of this. They don't follow up with.
No, but again, we submit that was enough right there. Jurors.
Didn't two other witnesses testify that your client tried to hire them to kill the victim in this case and the baby? Should the baby be born?
There was testimony regarding that. Two of the people had been arrested, and they used this to get out of the charge. One of them specifically, though, said, who was with the other, one person said kill. The other one, who was with him at the time, said, no, he wanted us to get rid of the baby. A third witness said that she had heard that the defendant wanted them to punch her in the stomach to cause a miscarriage for this alleged pregnancy. We would also submit two other cases, Ruth and town of West Palm Beach, cited in the briefs, are close to this. In Ruth, opinion of the police detective was that this airplane was used to smuggle drugs, and in town of West Palm Beach, it was a civil case where the issue was whether the benefits are real and substantial, and a witness was allowed to testify, not that this was some big benefit, but was allowed to particularly testify that it was real and substantial, and the courts held that this was error, this was improper opinion testimony. Again, the medical exam, or the fire marshal, did say it was intentional fire, but on cross-examination he clarified that by saying what he meant was that it was the use of an accelerant and there was no act of God like a lightning strike that was the point of origin of the fire. And again, he did admit that the defendant's account is not excluded by the evidence and could be what happened.
It seems to me that evidence here also indicates that he was watching her as she was on fire and drove away and did nothing to try to put the fire. If he accidentally set the fire, one would think that he would at least try to put it out, maybe call a fire department, do something like that. But he watched her as she was burning and then left.
The evidence also shows that the defendant himself set himself on fire. His arm was burnt, his leg was burnt. He drove off. He had to stop a little ways down the road to continue putting himself out. And coupled with the testimony during the penalty phase of the defendant's mental and emotional disabilities, his immaturity in the case, which the judge specifically found in the age mitigator, that if he had been mature as a 19-year-old rather than a 10 to 14-year-old, this never would have happened. He would have had another way of solving his problems.
But didn't he stop to get his car washed because she touched it?
Yes, that was after the
home?
fact. He was very concerned about his family thinking that he had gotten some girl pregnant. He was concerned about that, but that was after he had driven away. He realized afterwards, he said that he should have done more, but he didn't, and we submit that was because of his mental...
It's unclear as to what your theory is, or what the theory of defense was at the time. Somewhere along the line, he pulled into a 7-Eleven or convenience store with the victim in the car.
Yes.
He goes in and he buys a can of gasoline, duct tape, and perhaps even a light. Comes back in the car. He has gas in the tank. Drives to some secluded area. Takes it out of the car, duct tapes it, douses it with gasoline, and lights up a lighter. At some point in time, it is your contention that he was going to say, okay, I'm backing off. I just wanted to scare you. He was going to stop. You're saying. When was that going to happen?
Apparently after he lit the lighter, but it caught him on fire, and then in turn caught her on fire. He indicated that he was merely trying to scare her with this. He wanted to break off their relationship, that she wouldn't let him break off. And yes, he intended to scare her, but we submit that the actual ignition was an accident.
But isn't that just the most incredible story imaginable?
No, I don't think so, Your Honor.
I mean, people break off relationships all the time without having some scheme in which they wrap someone in duct tape, douse them with gasoline, and present them with a fire.
Again, the mental and emotional makeup is testified to by all of the experts, even the state's expert said he had a long-standing mental and emotional disturbance which contributed to this crime.
Well, that goes to whether the death penalty is proportionate. But going back to what you're hearing from the justices is a sort of a skepticism founded in the actual evidence that any reasonable jury could have found that this was an accident. And now what we go to, since we know harmless error doesn't have to do with whether there's overwhelming evidence, but the effect of this one statement on the trier of fact, I would just go back, and then I think we've probably exhausted this subject, is that with the state not having used the statement in closing argument, with it not being with it being used to explain why he might have said that during the interrogation, and I don't see how a reasonable jury could have possibly been affected by that statement. And I think that's really what we have to focus on, together with all the other evidence. And
we submit that, again, this was a law enforcement officer that jurors typically give great weight to.
I mean, did you have any expert to say that it was likely that this could have been an accident? In other words,
the state's own fire marshal said that, Your Honor. I believe it's at pages 300 through 302 of the transcript, volume 9. Bailey admits that the defendant's version is entirely consistent with the facts. This type of scaring it may seem extreme to us.
I was under the impression that there was some discussion with regard to this was out in the open, that the vapors and fumes would dissipate and would not occur spontaneously as it would if they were in a confined space. Is that not part of this record?
No, the fire marshal said it could be within a foot. And when the glove got lit on fire, it's entirely possible that the fumes, he was within 1 foot. Again, fire marshal, the expert, said it's entirely consistent. We may think this was an extreme method of scaring her. I agree with that. But the defendant apparently did not. This is a technique that's known for interrogation tactics for terrorists, where they say, we're going to light you on fire. So it does happen.
The worst statement was, when you questioned him, did you believe it was an accident? No, ma'am. So he was talking about what his state of mind was during the interrogation, not what his opinion was as to whether it was an accident. And it was a one statement, and it wasn't used again in closing argument. I think you have a hard time getting...
The trier of fact was told by a law enforcement officer, don't believe the defendant. I don't believe him. I don't believe it was an accident. The case law shows that triers of fact are being directed to arrive at a conclusion which they should be free to determine independently from the facts presented and not have this improper expert testimony.
But he's asking about the detective's own statement that it was an accident, not the defendant's.
Again, because the state presented that evidence, not the defense didn't open the door, the state did. They were the ones that made the necessity when they could have excised that from the statement, from the confession altogether, and we wouldn't have had this problem. Turning to point number 7, the defendant's death sentence was improper, where it was based on critical factual errors in the sentencing order, where substantial mitigation exists, and where one aggravator was not proven beyond a reasonable doubt, rendering the death sentence disproportionate.
Can I, in terms of the mitigation, clearly the evaluation for me of the extreme emotional distress mitigator is something important to look at. Now, the judge in her sentencing order said that that all the experts agreed that none of the diagnoses caused or contributed to the murder, and then found that Dr. Tressler's testimony was more credible, and then gave it the mitigator little weight. Can you you assert that statement is wrong?
Totally wrong. Totally wrong, Your Honor. Dr. Tressler, the state's own expert, could not say for certain that the defendant's disorders did not influence his conduct.
Well, let's go to what the positive is. What did your expert? What is the testimony that you say really shows that this was a case of an extreme emotional disturbance having been a factor in causing this crime?
Right. First of all, Dr. Tressler, again, the state's own expert, said, and I quote, "The defendant has a long-standing disturbance which interferes with his inability to function in certain areas of life, and he has a hard time operating within the standards of society."
Well, how does that, just going to what facts in the defendant's background actually support even those statements? In other words, he didn't graduate from high school, but he was holding down 2 jobs. He was carrying on 2 different relationships. He was working in his father's business. He had an IQ that was
low average.
Was much better than many of the defendants that we see.
All the experts agreed that he had mental and emotional disabilities which caused him to function, some said as low as 10 and a half years old, others said between 12 and 14 years old.
But what is the factual basis for those statements?
The tests that were done on the defendant, the school records showing that he had disabilities growing up, and in school.
Well, learning disabilities? And what kind of disabilities?
He had learning disabilities. He had mental and emotional.
Well, that's what I'm trying to ask. Well, how did until the date of this terrible crime, how did those mental or emotional disabilities manifest themselves?
They manifested himself mainly in his school setting and his social and interpersonal relationships.
How? Give me 1 or 2 concrete examples so that we don't just have an expert saying something caused it or something, of how he did not function in a way that when he was subject to something very stressful that he would lose it.
They, based on their social, the data that the doctors acquired from witnesses, from school records, they all said that when faced with an emotionally highly charged situation, such as occurred here, Dane would have difficulty operating normally.
I understand. You're giving me a conclusion. And I realize that's all you have to do. But in terms of it for being a case where you can take this is a terribly aggravated crime in terms of the circumstances, if we uphold both HAC and CCP and you haven't attacked HAC, you've got a 19-year-old, you've got someone who does not have a prior history of crimes.
Correct.
Which is both good, cuts both ways, because he doesn't. It's good. But it's also questions, well, how come now he acts out? And you've got age as a mitigator, but I'm looking at this one, the extreme emotional disturbance, and I'm not satisfied just to hear conclusions. I want to understand what it is in terms of the diagnosis or the circumstance that would show that he had the kind of personality disorders that would have caused this irrational decision to be made, and was operating at the time of the crime.
Again, all of the experts testified based on the facts of the defendant growing up that he had an impulse control disorder. He was unable to resist impulses.
Tell us about the fact of his growing up. what was wrong, or what do you say was dysfunctional or unusual or something about his growing up?
He had emotional issues where he could not cope with certain types of situations. And
Can
that
you
was,
give us one example? I mean, that's what I'm asking you. Is there what did the expert rely on to show, based on school records, that he was a behavior problem, that he had to be taken out of school?
No, actually, he wasn't a behavior problem in school. The records showed that he tried as hard as he possibly could. He got perfect attendance for being at school, but he was, because of his mental capacities, his emotional capacity, he was just not able to learn, and the doctors correlated that to his social aspects of life, that he was not able to deal with stress and highly emotionally charged situations. There were specific examples where the family had to have him Baker acted when he returned from visiting his father in Trinidad. His biological father also had some mental disabilities. He was Baker acted. He was released. He lived with his uncle for a while, was allowed to return home. He cried incessantly over this. He had emotional problems that Dr. Gould especially correlated to his life.
Is that the only one? It's really a pretty straightforward question. And again, is the record just not contain the material? Did he hit people? Did he run over them with motor vehicles?
No.
Okay, so I mean, the record just doesn't contain those. It contains the conclusions of the expert. That's better. Just go ahead and approach it that way.
And all the experts, though, I would disagree. If there was an expert that said, no, he has no mental or emotional disabilities, no, they didn't affect him, then yes. But all the experts agreed here, contrary to what the trial court's order said.
The only thing that we have then in this record, how that translated, was that he was Baker acted on one occasion. Is that what the record shows?
And his disabilities in school with learning, the fact that his brother was extremely smart and he had to deal with being compared to him all the time, and the stress that caused him, as testified to by Dr. Gould. Also, the trial court did find age to be a mitigating circumstance here, but only found it moderate weight. Under this court's decision in Bell versus State, the court must afford age full weight, it says, unless there is a showing of unusual maturity. Here, the trial court's order specifically shows the exact opposite, that he had a lack of maturity. He was unusually immature.
Mean? What does full weight? You said that says we have to give it full weight.
Yes, Your Honor.
What does that mean?
That was the court's language in Bell.
Moderate?
Moderate is not full weight. Moderate is kind of middle of the road weight here. And
so, are you saying we need to give it great weight?
Yes. I submit that
that's
full
what you
weight
interpret
and great
full
weight,
weight to
are synonyms in that regard. It certainly isn't moderate weight, and the judge's own order supports that it should have been given great weight when he specifically says, if the defendant hadn't suffered from this immaturity, this wouldn't have happened. We submit that he was barely age qualified under Roper versus Simmons, but when it's coupled with his intellectual and mental and emotional immaturity, it's a strong mitigation that says the trial court must give full weight to. And here the trial court did not, discounted it, only giving it moderate weight. We submit that this court should reverse the conviction, remand for a new trial, and vacate the death sentence. Thank you.
Thank you.
May it please the court, Meredith Carbula, Assistant Attorney General for the appellee in this case. I'd like, if I could, because of recency, take up the last issue that the appellant brought up. I'd like to correct a couple of things. First of all, not all the experts said that Mr. Abdul had an impulse control disorder. In fact, Dr. Tressler said specifically he saw no evidence of an impulse control disorder in Abdul. He also opined, contrary to Dr. Gould, that there was no evidence of psychotic delusions. And Dr. Gold said she had a diagnostic impression. She doesn't do diagnosis because they change all the time, but that he had psychotic delusions because he reported that he drove Lamborghinis and Ferraris in his father's auction business. So Dr. Tressler, who, by the way, the trial court found more credible than Dr. Gold, found that Abdul had a personality disorder. And specifically, Dr. Tressler testified that, in his opinion, the defendant's personality disorder did not cause him to commit the crime he did. And that's on page 1215 of volume 15 of the record.
Here's my just my question is that it seems that in using the statutory mitigator, the judge put in the statement that both of the experts agreed the defendant knew right from wrong and knew the consequences of his action. And there was that kind of cross-examination about whether he was competent, whether he knew right from wrong. And you would agree that the standard for whether someone suffers from extreme emotional distress to qualify for a statutory mitigator is entirely different from whether they know the difference between right and wrong?
Certainly, but Dr. Tressler opined that neither statutory mitigator applied. Dr. Gold testified that they did.
And that's the other part, is that there is this statement that the judge makes in the sentencing order. All the experts agreed that none of the diagnoses caused or contributed to the murder.
Correct.
Whereas Dr. Gold, whether we think it's more credible or not, did say that the defendant was under these extreme emotional distress
She
at
did,
the time.
yes,
Okay.
she did.
So that's, and the other part that I'm concerned about with the judge's order is that, and it's raised indirectly, is that in finding or giving weight to non-statutory mitigators, every time the judge says there's no relationship between the fact and the crime, the judge gives that mitigator little weight. And we have said over and over again that non-statutory mitigation doesn't the whole idea is it's any aspect of the defendant's character or background can be found as non-statutory. Now, you may not find it's an important one, like the fact he plays soccer. You'd say, well, it's just not one that we're going to give much weight to. But it seems like the judge gave little weight if she didn't find it was related to the crime. And I'm concerned about this, that misconception of the law regarding non-statutory mitigation.
Well, I think that what you see actually is that in a lot of those areas, Dr. Tressler has differed with Dr. Gold, and as I say, several places in her order, she finds Dr. Tressler more credible. But I think what she was doing was trying to give the defendant a benefit of the doubt. Now, this court has, it's clear that any mitigation can be any evidence regarding the defendant's life can be mitigating, but it's entirely appropriate to weigh it differently, I think.
I would agree
if it's related to the crime or not.
Give no weight, but I think that if you go on this idea that if it's not related, we're going to give it little weight, we have really undermined non-statutory mitigation. And, for example, attention deficit disorder, and I haven't looked at the school records to know what that really means in the context of this case, but the judge says, well, the court finds it to be a mitigating factor. It gives it little weight for the reasons set forth in B and F, and B and F of the sentencing order go back to the statutory mitigation. And that's what's done repeatedly in this sentencing order. And my concern is that led to the non-statutory mitigation not being weighed in a way that we can truly evaluate it. And I'm also, just in terms of the proportionality analysis here, the defendant, there is a point about the fact that if he's 19 and he is functioning as a 12 to 14-year-old range, that should have been given greater weight Now, that whether that changes the equation, I don't know, but we really, for 19 now, since it's, you've got someone 18 or 19 who's going to be really what a 17-year-old might have been before Roper, the age mitigator is something to consider. Would you agree? I mean, in other words, I guess I would ask it differently. If we conclude that mitigator should have been given great weight, what does that do to the proportionality analysis?
I think it does nothing, because you see that the trial court said that if he would have been a little bit more emotionally mature, that he may have made decisions. I mean, she gave it moderate weight, but it's clear she viewed that in terms of that if he would have been more mature, he would have made better decisions. Dr. Trevor rejected the notion that he was 12 or 14. He says that emotional age is really not very scientific, but he did agree that he was emotionally immature. But here we have a defendant who is holding down 2 jobs. He's got his own apartment, although it wasn't for very long before the murder. He has his credit card. He drives a car. He's operating in every way like an adult. He went to trade school and learned a trade. So we see him operating as an adult in society. And so I think so I don't think, based on what the trial court concluded was the age mitigator, that it would have made a difference in this case, because I think she clearly considered the defendant's age and his emotional immaturity.
But the trial court didn't say, well, that's why I'm going to find this mitigator not to have great weight, because even though someone says he's functioning as a 12 to 14-year-old, I find that he actually had the maturity of an adult. So we don't have that as a finding from the trial court. In fact, the trial says the opposite. It's likely that if he had been more mature, that this terrible crime would never have occurred. I mean, that's what she ends up saying.
Right, but I think elsewhere, and she talks about his job performance. But I think that when you see that language, you see how that the trial court did consider that factor. And I don't think that if this court directed, which of course this court has never directed the trial court to give a particular weight to a mitigator, that would have made a difference in this case.
Well, in the whole 19 years of this defendant's life, was this act totally out of character with the way he had lived his life?
Apparently, and even Dr. Tressler said that it seemed an aberration.
And the planning of it, which does give rise to the CCP, started 2 hours before, as far as the purchase of the gasoline and the duct tape.
Correct, but he had previously asked Julian Pinnock to kill Amelia for her.
Well,
for him.
When was that, and what was the circumstances?
It was some months before the murder, and Mr. Pinnock said that he hadn't been acquainted with Mr. Abdul. He had no idea why he would be approaching him to do this, and he turned him down. And he said, Abdul said he'd find somebody else. He also told Lalita Bhikkhu that he wanted to kill Amelia because she had vandalized his car and his mother's place. There was absolutely no evidence of. And that took place sometimes before the murder. And when, confronted with the fact that he was arrested for the murder by a friend, Amanda Inman, he told her that words to the effect that a person can only go so far, can only be pushed so much. And yes, we have the actual, the record doesn't have when he actually planned it. We do know that he bought the duct tape, the gas can, and the gas en route to the kill site. We do know that.
Well, we know, if we didn't have CCP, we'd have a whole different equation. So, I'm accepting that they're CCP. But the cases that the state uses for comparing for proportionality are, to me, so far different. The cases of, like, Way, which involved a 38-year-old man who killed his mother, his wife and his daughter, and had a prior violent felony. Zakruski, who was an older man who killed his wife and 2 children. What is in terms of looking at this, of a young defendant who has had no prior history of criminal activity, and with age being given at least moderate weight, what is the closest case on proportionality that we have?
I cited to this court to Robertson, and even though the defendant was 29 years old, he had frontal lobe damage, and he was under the influence of cocaine at the time. And I believe this court has upheld the death sentence in cases where the defendant is rather young. In the Looney case, I believe he was 20.
Again, and not to undermine anything, but the Looney, was that the one with the 2 deaths?
That's correct. That is the 2 deaths where they came in and they home invasion, and they shot the couple in the bed and then lit the trailer on fire.
And there was, I'm sure, there was a pecuniary gain motivated.
Right, and it was a robbery, home invasion robbery.
Well, let me ask, let's go back to the sentencing order, because one of the things that struck me about the sentencing order is that the trial judge, went through all of these 48 or so mitigating circumstances, and quite often we see in these sentencing orders that some of these things, like the developmental delay and other things about his are usually lumped in with the emotional disturbance and with not being able to conform his conduct to the requirements of law. So quite often we see all of these things that she's taken out and put in as separate non-statutory mitigators, sort of lumped in with the statutory mental mitigators. And what is the state of our case law as to whether or not that is appropriate? I mean, if she had taken all these things and put them actually with the statutory mitigators.
Well, I think that, juries are not instructed that they must give more weight to statutory mitigators than they are non-statutory mitigators. And, as the court found Dr. Tressler's testimony more credible than Dr. Gould's insofar, and he opined that neither statutory mitigator applied in this case. And so I think what you see in the trial judge's sentencing order is that every non-statutory mitigator, which I think she found a lot of them duplicative, that was requested to be considered by the defense, she gave consideration of and gave some weight to, even though, for instance, Dr. Tressler testified that there was no connection between the personality disorder did not cause the offense. And I think how he described the personality disorder is that the behavior is what denotes the personality disorder. It's not the personality disorder that causes the behavior. And he explained that. So I think what you have is a trial judge who's been very careful about considering every possible non-statutory mitigator and mitigator suggested by the defense, and giving the defendant every possible benefit of the doubt, even when...
What, if anything, did she do with the fact that he had been Baker Act? And could you tell us under what circumstances that occurred? I mean, I've known of people who've been Baker Acted, and, they stayed in for those 3 days or whatever it is that you normally stay under, and then are perfectly functional. So I'm not sure what were the circumstances of his having been Baker Acted.
I can tell you, Justice Quince. What happened is that he rebelled against his mother's rules. I mean, his parents were devout and religious. They raised him in a home with rules and structure and no alcohol, no running around. And he rebelled against his parents' rules, and he ran away, and he left his mother's home, giving her an indication he was planning on running away. His mother called the police. They went out and scooped him up, brought him home, and he made a comment to the effect of, "It's just better I'm not here." And the police took that as a suicidal threat They took him into Lakeview, had him evaluated. He was released less than 24 hours later with no follow-up counseling. And his mother never thought he was suicidal. It was sort of a precautionary measure taken by the police when he made that statement. He went at one time to live with his uncle because he felt confined by his mother's rules. So that was a situation. There was never any indication that that was a result of any mental illness. It was basically a prophylactic measure taken by the police when he made a statement that, at least in the police officer's view, but not in Dane's mother's view, that that was a suicidal threat. And so that's what the Baker Act, he didn't even stay 24 hours.
I know you're going to say it's not that it's distinguishable, but the case that to me comes closest is the case of Bell v. State, which was reduced to life based on a proportionality analysis, and it was a pretty terrible crime. I mean, it was not a. I was just looking back at it. He was a 17-year-old, but the majority did not base its decision in that case on just the mere fact that he was 17. How would you distinguish Bell?
If I could have a moment. I'm sorry, Your Honor. I don't recall the facts of Bell. I think that may have been...
After two oral arguments in a row and your perfect knowledge of the record, I think your brief actually may have...
I apologize, Your Honor. I just simply can't remember the facts of Bell right off the top of my head. But I think what we see here is very careful planning of the defendant, his frustration at Ms. Suktio wanting to pursue this relationship. So if I might move on to the first issue, which was the police officer's testimony, I think that what we have here, I agree, and I think I acknowledged in my brief, the questioning of the prosecutor could have been a little bit more vague, and I noticed that you seemed to go along with the defendant in many areas of his interview. What was that all about? Might have been a better question. But what you have here is the officer did not opine. I think this is first-degree murder. I think this is second-degree murder. He was asked a question specifically about, I noticed you went along with the defendant and then several times said you agreed it was an accident. What was that about? And he said that's an interview technique.
It was really the first comment where he said, when you were going along and saying it was an accident, did you believe it was an accident? That's really the one that I guess they're hanging their hat on, not maybe with some concession that the other comments would have been better. But what you seem to be being forthright about it is that it would be better to have, if they were going to ask it at all, to just say when you were making these comments, why would you make, not what did you believe, but why do you make these comments? And
correct. And it could have been more artfully done, absolutely. But what I think you have to look at is, and I think in looking at it, you can see it now, because had that question not been asked, then certainly, given the defendant's defense, during closing argument, the defense would have been, look, even the police officer thought it was an accident. He said it several times on the tape. And it's okay, the comeback is, well, the state could have said, well, it's reasonable to infer that that was an interview technique. But without the actual evidence of that, it's only an inference. With the evidence of that, it's an evidence of that. And as pointed out by the prosecution did not then get up on closing and say, and we know this wasn't an accident because we have Detective Juan Bailey who testified it was a fire intentionally set. And we also have Detective Gamble who's testified it was an accident. That didn't, of course, happen. And so what we have is explaining why the defendant or the police officer use that particular interview technique. The defense counsel did not ask for any kind of limiting instruction on that point. And maybe probably for tactical reason, he didn't want to emphasize it. But also, so we have the state not arguing that in closing argument. And so I think that when you look at the fact that Detective Bailey testified without objection, this was a fire intentionally set, and you have the questioning in the context of this being used as an interview technique as opposed to an opinion, no reasonable juror would have put weight on that was an opinion, and certainly he didn't opine it was premeditated murder or any kind of particular crime. He only said it wasn't an accident, and then in context explained that was his interview technique. So I would say that there was no error, or certainly any error, and that was harmless error. Absent any other questions, the state would ask that this court affirm Mr. Abdul's conviction and sentence to death.
Thank you. Rebuttal?
Thank you, Your Honor. May it please the court. Specifics that were mentioned during the penalty phase concerning the defendant's mental and emotional disabilities, page 1111. At the time of the crime, his intellectual level was the equivalent thinking of a 12-year-old child, socially at age 15-year-old, regarding the fact that he had jobs and had a car. Specifically,
who is making these statements that you're now reading?
This was Dr. Gould, Your Honor. And she's the one that did all the social interviewing and reviewing the records. Dr. Tressler only spent like 2.5 hours total on the case. She was the one that delved into these things. Regarding
Are the records in evidence, the school everything that we would need to look at to see what the opinions were based on?
No, they were the test results and whatnot were provided to the state's experts, but they are not part of the record, from my understanding. Regarding the fact that he held 2 jobs and had cars and had gone to tech school, the testimony was he really didn't understand how cars work. He just thought they were cool and fast and sleek, that he really didn't do the welding properly that he had gone to. There were developmental disorders were pervasive. He was younger in every way than people his own age. This was across the board. All the psychologists and educational specialists knew. Roper talks about the reason we don't execute juveniles is because of their immaturity at the time of the crime. Here, the defendant clearly thinks like a 12-year-old rather than an adult. He had a credit card and he had an apartment. He only was out on his own for about 2 weeks, and these were provided by his parents, so he wasn't really on his own. He didn't have that level of maturity. He had separation anxiety disorder where he was very, very dependent on others, and it would upset him if he was separated from them. Again, as Justice Perriente mentioned, the trial court goes into in regarding the mental mitigating circumstances that the defendant knew right from wrong. Totally irrelevant to the mental mitigators here. That goes, of course, to insanity and guilt or innocence, or guilt or not guilty, and has nothing to do with the mental mitigators. The statements to prior people, wanted to kill or cause a miscarriage. This happened in the fall of 2004, which is 4 to 6 months prior to this crime. So apparently she was 4 weeks pregnant for about 6 months. So those statements just don't gel with what went on here.
Well, I thought there was something in the record that said that she had been pregnant at one point, had an abortion, and then was pregnant again.
Yeah, there was also testimony that the defendant never was told about this.
Could you just let me finish?
I'm sorry.
I thought that the testimony or something in the record indicates that this was supposedly a second pregnancy. That's not true?
Yes, there was testimony of that. There was also testimony that the defendant wasn't aware of that alleged pregnancy. She had told that to a friend or cousin, I believe. So that couldn't have provided the impetus for these statements. The state, regarding the statement of the opinion of the police officer, they say that reasonable jurors would think that without this clarification, without this improper question and answer on opinion, these reasonable jurors would think that this was an accident, so they needed to present this. But then they say that these same reasonable jurors would not believe that that was the detective's opinion and that they should follow it, but it was just a clarification. So they can't have it both ways on that. We submit that, especially because of his age, coupled with his mental and emotional issues, that this is not a case that cries out for the death sentence. Thank you.
Thank you both for your arguments here today. The next case on the court's agenda is Schatz versus O.P. Winter Haven, Inc.
May it please the Court, Isaac Ruiz-Cruz and Benny Lazaro on behalf of the petitioner. I'd like to reserve 5 minutes of my time for rebuttal. This case presents irreconcilable conflict between the 2nd District Court of Appeal and the 4th and 5th District Courts of Appeal on a narrow issue of law, and that is whether the inclusion of the American Health Lawyers Association rules in an arbitration agreement between a nursing home resident and a nursing home licensee violates public policy and is not severable in spite of the presence of a severability clause in the arbitration agreement.
Does this case present the issue of whether it's, because I know we have a companion case, I think you're arguing, as to whether the decision is one for the judge to make or the arbitrators?
It does, Your Honor.
Right. And in the record, I was searching for it. What are specifically, what do the American Health Lawyers Association rules do? This one doesn't have your case, this doesn't have the limitation of the compensatory damages, at least like the Agessa case. So what are those, do we have anything in the record as to what those rules are about?
We do. I think it's in the lower court. The rule under the American Health Lawyers Association was Rule 606. It's now been renumbered. It's Rule 4.12. What that does is it raises the burden of proof to clear and convincing evidence for special and consequential damages. In addition, this arbitration agreement also includes an elimination of the right to seek punitive damages.
But, okay, so on the rules, though, it changes the burden of proof?
That's right.
I mean, not that that's a minimal thing. That's and how, I mean, and I guess, because I know you raised, in this case, unconscionability as in addition to public policy, and I'd really ask this to your opposing counsel, how would somebody reading this document with his arbitration clause, the arbitration clause, and then the statement that you'll be bound by the American Health Lawyers Association rules, know what that limitation would even be about?
They wouldn't.
Did you make that argument below, that not just that, on the procedural and substantive unconscionability?
The argument that was raised below, based on the record, because the record evidence is the deposition testimony of Ms. Schatz, who was the niece here, and she was signing her uncle into a nursing home. And none of this was explained. And that when she asked questions about the arbitration agreement, that what was told to her is that you need to sign these documents.
But I thought the agreement itself said that you did not have to sign this agreement in order to get a patient into the nursing home. I mean, and it seems to me that her argument is that I felt compelled to do this while she wasn't compelled to do it, was she?
Well, the language of the agreement, you're correct, Your Honor, does state that this is a voluntary agreement. But then the impression, the facts and circumstances, which is what the court should look at involving procedural unconscionability, as the district courts of appeal have resolved the issue. Now, I think that it begs the question of whether or not that's the correct analysis on unconscionability, but looking at just the facts and circumstances surrounding the making of the agreement, the impression that was left, and this is from the employee of the nursing home, was that this had to be signed. And that was the testimony of the niece repeatedly in her deposition, that this had to be signed, contrary to what the express language of the agreement was.
What is the the argument, if it's void as against public policy, you don't have to get to the unconscionability?
That's correct,
And
Your
it
Honor.
seems that as you read the courts and their attempt to explain unconscionability, which is sort of different from what I remember from law school, I don't remember these two-part procedural substantive unconscionability dichotomies, but that it's an easier argument to be made that it's void as against public policy than to try to go through this sort of individualized decision in each case. So is your argument on the first is really that it's void as against public policy?
That's right. And on the unconscionability analysis, we would agree with Your Honor. And in fact, the 11th Circuit recently asked this court in Pendergast, it certified the question about unconscionability because there is a conflict between the district courts of appeal, the second, which applied in this case, the test that you have to have both independently, procedural unconscionability and substantive unconscionability. All of the other district courts of appeal apply a balancing test or sliding scale approach, where if there's some quantum of one and an amount of another, that's sufficient for unconscionability. The reason why you might not remember it from law school, Your Honor, is because this division wasn't
there
devised.
So long ago, huh?
Wasn't devised until.
Wasn't informed.
I didn't say that, Your Honor.
Don't go there.
This court hasn't addressed the issue of unconscionability.
So, well, okay, on the conflict question, though, so to get there, if the conflict issue is, again, in this case, that it's the judge versus the arbitrator who should decide these threshold questions. And then in the threshold questions, both is it void against public policy, and then the second one being unconscionability and whether they've applied a different test. If we decided based on void as against public policy, would you still urge us to reach the unconscionability
It is
question?
Unnecessary, Your Honor.
But you said there's still a conflict out there.
There is a conflict, but on the narrow facts of this case, for my client, the court can resolve this case on the issue of public policy.
But on the unconscionability issue, all of the districts basically say you have to have procedural and substantive unconscionability, right? It's just a matter of degree that we're talking about.
If I could, just for a second, the entire division between procedural and substantive unconscionability evolved in 1981 when the 3rd District came out with a decision involving apartment rentals and leases. Prior to that, this court followed the Hornbook approach in Williston on contracts, and that is that unconscionability is this muddy concept. You may look at whether it's contract of adhesion. You may look at the unequal bargaining power of the parties. You may look at the substantive terms. But there was no requirement that there be two separate elements. The 3rd District in that decision cited to no case of this court, cited to no prior Florida case. It cited to a New York Federal District Court decision which involved and had some mention in dicta about two different standards, procedural and substantive, but did not require the two. That's when they started requiring the two elements, procedural and substantive. It was an innovation by the 3rd District. The other DCAs adopted that. Now, in Steinhardt, the 4th District mentioned that this is a muddy, evolving concept and that there may not be a requirement that both be proven. So there is, I think, an open question. It is true in the nursing home context. All of the district courts of appeal who have looked at unconscionability have applied some amount of procedural and some amount of substantive unconscionability. The actual test, whether it's balancing, sliding scale, or the full independent amount of both, that's where there's a clear conflict. But this court could clarify the law on unconscionability since it has never spoken on the issue conclusively as to whether or not there have to be both proven. And that may be something the court chooses to address in this case, or it may choose to address it in the certified question in Pendergast.
Do you agree that the Federal Arbitration Act applies to this case?
Your Honor, the Federal Arbitration Act, yes, applies to the first question, and that is under Buckeye, whether or not if a challenge is made to the agreement as a whole, then that's for the arbitrator to decide. If the challenge is made to the arbitration agreement, then that's for the trial court to decide.
Right.
This is a challenge to the trial court.
The contract specifically says the Federal Arbitration Act applies, not Florida Arbitration Code, correct? That's what it says.
Well, it says that. It also says Florida law applies.
Well, okay. As we're determining who decides whether it's the court or an arbitration panel, that issue is before us today.
Yes, Your Honor.
What law decides that issue?
Seifert decided that issue, Your Honor.
What law? Is it federal law or state law?
It's both, Your Honor. It's state law governs. If I could explain, Your Honor. Under Buckeye, it's a federal question whether or not the arbitration agreement, when it's embedded in a larger agreement, is severable.
Under the Federal Arbitration Act.
Under the Federal Arbitration Act.
Not the Florida Arbitration Act.
That's completely correct, Your Honor. And that's under sections, Justice Scalia interpreting sections 2, 3, and 4 of the Federal Arbitration Act. But once you get to the first prong, which is the validity of arbitration agreement, there is uniformity in the U.S. Supreme Court, and this is also true in the Rent-a-Center oral argument, in which the question of unconscionability was raised, whether that's for the arbitrator or the trial court to decide, very recently in the U.S. Supreme Court. Uniformity that state contract principles apply to what goes to the validity of an arbitration agreement. So it's true that the initial question is an application of federal substantive law. But once we get to what goes to the validity of an arbitration agreement, we apply state contract law principles.
Okay,
but don't we have to...
The decision as to who decides, whether it's the court or the arbitration panel, isn't that a matter of federal substantive law applicable to the Federal Arbitration Act under Moses Cone?
Well, the analysis, Your Honor, that I'm suggesting, and that Justice Scalia suggests, and that is consistent not only with U.S. Supreme Court precedent, but also with this Court's own precedent under Seifert and under Global v. Shea, is that questions as to the validity of the arbitration agreement, which public policy would be a question as to the validity of an arbitration agreement, unconscionability would be a question as to the validity of an arbitration agreement, are for the trial court to decide. That's consistent with the Federal Arbitration Act, with Section 2 of the Federal Arbitration Act. It's also consistent with the Floor-Arbitration Code, 682.03 subs 1 and sub 4. Both of those sections leave the question of the making of an agreement to the trial court.
Let me take you to Buckeye, because you seem to concede that Buckeye is something that we have to deal with here.
Absolutely.
Buckeye governs.
Yes, sir.
Well, if we look at Buckeye, Buckeye sets up two different categories of challenges. One is a challenge specifically to the validity of the agreement to arbitrate. Okay. Now, you claim that what we've got here falls within that category.
That's correct. Yes, Your Honor.
The other category in Buckeye are challenges to the contract as a whole. Correct?
That is correct.
Okay, but when they explain challenges to the contract as a whole, they say either on the ground that directly affects the entire agreement, for instance, that it was fraudulently induced, or on the ground that the illegality of one of the contract's provisions renders the whole contract invalid. Now, it seems to me that what you're arguing here specifically is that one of the contract's provisions, that is, these provisions related to remedies and the other things that come in to govern the resolution of the case, render the whole contract invalid.
No, Your Honor. And this is the simple...
Explain that to me. Explain to me why that's not so.
Because in Buckeye, this is the agreement, and contained within it was a provision, was the arbitration clause. The challenge that was made was that the contract as a whole was usurious, and therefore void as a matter of Florida law. That went to the contract as a whole, not to the arbitration provision. The record in this case, because after Buckeye, the defendants, the nursing home operators, started changing their arbitration
But the focus here is not on the language of the agreement to arbitrate. It's on these other things related to that, it seems to me.
Not at all, Your Honor.
Okay.
Here is the explanation of binding arbitration from the record. This is what we are challenging. Within the binding arbitration agreement, the inclusion of the American Health Lawyers Association rules. It's in the first paragraph of the binding arbitration agreement. This is specifically a challenge directed to the arbitration agreement. The parties' agreement here was to arbitrate specifically with the American Health Lawyers Association and to utilize their rules. That is a matter of state law, not a matter of federal law.
So really what it's intertwined with, and I had my notes in the other case about this, is severability, because you got to go and say, let's assume this is invalid. Is it severable? If it's severable, then the arbitration agreement is valid. So it is almost something that the trial court has to perform a two-part analysis in order to decide if the arbitration agreement is invalid. Would you agree with that? If the trial court finds it's an illegal provision in the agreement, but it's severable, then the case can go to arbitration. If they decide it's not severable, then it stays with the trial court. And I mean, it seems to me that that's why it has to be decided by the trial court, because only the trial court is going to be able to do both of those prongs, and if they decide it's not severable, then the agreement to arbitrate is not valid. And that would be clearly within the Buckeye dichotomy. But you have to get to the severability part as part of the two-prong analysis. Am I getting that wrong or
Well,
no?
I don't think it's necessarily compelled by the analysis. The fact that
Well, because if the agreement to whatever it is severable, then the arbitration agreement is valid.
Well, Your Honor, under the Seifert case, I would suggest that part of the problem with respect to, and this is something that Judge Altenburn mentioned in his concurring opinion in the Steele versus Manorcare case. It's something that Judge Northcutt alluded to in his concurring opinion in the Stoyer case, both of which this court has stayed jurisdiction on pending these two appeals. The issue becomes, as this court announced in Seifert, because arbitration here for a protected class of persons, nursing home residents, involves the waiver of certain constitutional rights, that waiver ought to be knowing, intelligent, and voluntary. In Seifert, this court acknowledged that the waiver of certain constitutional rights, access to courts, due process, and jury trial, is involved in the action of arbitration. And this court also observed in Seifert that it has to be knowing, intelligent, and voluntary. And there is no assurance. There's been no finding by the lower court here.
I'm not sure. Maybe I'm Justice Kennedy was asking you about how Buckeye applies, and you were giving a reason why the decision here is the validity of the arbitration agreement, not the contract as a whole.
Yes, Your Honor.
All right. And my only question to you was that there's got to be that there's two parts in it, with severability being part of the analysis as to whether the arbitration agreement is valid.
That is the narrow analysis on the facts of this case.
All right.
Yes,
So
Your
in
Honor.
this case, why? And you're in your rebuttal, but I think that's since it's part of the sort of the conflict. This one has a severability clause.
It does, but both Fletcher and the Place of Vero Beach, the 4th and 5th districts, found that the choice of rules here, the party's intent to use the rules of the American Health Law Association, are so integral to the agreement that they cannot be severed. This is not a bilateral contract.
So, but we have to decide. That's the second conflict issue we have to decide.
That's
in
correct,
this case. Because if we agree with the second, then this case goes to arbitration.
If you agree with the second.
Without the offending provisions in there.
Well, the second did not come out and say that this actually violates public policy. But
well, that's
yes,
because they haven't got to the first point as to who decides it.
That's right, Your Honor.
Following up on Justice Perianti's comments, why shouldn't the trial court initially make the determination of severability as a matter of law, appropriately so, and then, if it can be severed, sent to the arbitration panel as all the other federal courts who have looked at this, as far as I know, do so?
Well, in Palladino, the 11th Circuit began by just finding that limitations violated under Florida law public policy. The 11th Circuit then, in the Anders case, looked at the presence of a severability clause and, under Alabama state law, found that that was an issue for the arbitrator to decide. Under Florida law, the fact that these provisions violate public policy, if we left that to the arbitrator, that would be something that could escape judicial review. And that's a significant issue with leaving these particular issues to arbitrators and not having the courts decide in the first instance that these violate public policy.
Well, that's a good public policy reason for the courts to decide it, but if we're bound by Buckeye, then we still have to stay with the Buckeye dichotomy between the contract as a whole and I wasn't on Buckeye, but it seems to me that both of those questions should be for the courts, but the Supreme Court has held otherwise, and knowing that these agreements will not be tested by judicial review because they're confidential. So we can't really, the public policy reason for the judges deciding it really has been decided by Buckeye, hasn't it?
It has, but I think that the policy I just espoused is exactly the policy in Buckeye, that the validity of an arbitration agreement is for the trial court to decide using state law principles. Thank you.
All right.
Please, the court. Tony Cifuentes for the nursing home. I'd like to start, if I may, with the power of attorney issue because I need clarification on this point. Tandem introduced a power of attorney into trial court, into evidence. That power of attorney specifically granted to Ms. Schatz the power to commit the resident, Mr. Clark, to arbitration. The state raised two defenses, and it also said that the Second District Court of Appeal shifted the burden on that issue. Now, on the first offense, they raised incapacity. And here's the problem, that specific defense, because throughout these proceedings, at the trial level, Second District Court of Appeal, and in this court, they have presented Ms. Schatz's testimony in deposition as stating that her uncle, Mr. Clark, was adjudicated incompetent in a court in New Jersey in 1981 or 1982.
I do want to stop you, actually, because before you go on this. Is this an issue that is a subject of conflict between appellate courts?
They have raised...
I'm asking you whether it's...
I don't think it is a conflict.
Okay.
The estate has raised an issue that the Second District Court of Appeal is in conflict with other districts on the burden of proof.
But if we get to their main issue, which is that it's wrong for the Second District to be throwing issues about void against public policy and arbitration clauses to the arbitrators, and that this is void against public policy and it's not severable, the power of attorney, it's another way that there is conflict on those issues. So.
Well, Your Honor, this is a gateway issue. This is a mutual assent issue. This is an issue that was raised at the trial court. The power of attorney is an issue of contract formation. It's a gateway issue under Buckeye.
So what is the conflict with the other appellate courts on that issue?
Well, the alleged conflict, Your Honor, is that the Second District Court of Appeal shifted the burden of proof on the power of attorney. That's the conflict that they're raising. And very simply, the point that I wanted to make is that there's no record evidence here that that Ms. Schatz didn't have authority to bind the resident to arbitration because Mr. Clark was incapacitated. There is no record evidence on that.
Would you go to the point that they were discussing previously, which I think is very significant in this discussion and this analysis, and that is given the federal Supreme Court's interpretation after this court already passed on several of these issues, whether there's room for a discussion. Your opposition says is that even after those Supreme Court cases, that there is still an area in which trial courts operate. And is that correct? Is that incorrect? And what's your view on the status of the law with regard to who decides what? The arbitrators, what do they decide? What still remains for a trial court, if anything? Could you address that? That seems to be really at the heart of what we're talking about.
Buckeye controls this case.
But I understand, and your opposition, though, says there's still an area within the Buckeye analysis where trial judges, trial courts, still have room to operate. And would you discuss that?
Under Buckeye and under Seifert, there are three three things that, under Seifert, there are three things that this court has to consider on the issue of whether this case, on the issue of whether the arbitrator or the court decides the public policy issue. The first prong in Seifert is whether a valid arbitration agreement exists. That's the question. Buckeye says that is an issue of contract formation. What they're doing in this case by raising the issue of public policy goes to an attack on the contract as a whole. There is no conflict.
That's what he's saying is no, it's not. He's suggesting that the attack in this case is on a part of the arbitration aspect, not on the whole contract. That's the distinction, as I understand it, that's being made. And that's what I would like you to address. Is that distinction valid? And if not, why not? I assume it's not valid, so why don't you tell us why it's not?
It is because under Buckeye, that is not the analysis. Under Buckeye, what the court has to look at is whether the agreement the attack is an attack to the contract as a whole. Well, and that is exactly what they're doing here. They're asking the court to invalidate the total contract.
But
they're not asking.
Let me just. But we're looking at binding arbitration agreement. That's in this case the binding arbitration agreement is separate and apart from whatever other contract existed between the nursing home and the patient. So what his point is that unlike Buckeye, where there was a usurious rate that went to the contract as a whole, here, if the provision is not severable, it invalidates there's no binding arbitration agreement if it's not severable. And so I guess I'm having, because the nursing home elected to put this binding arbitration agreement separate, I guess they could have done it where they had a contract as a whole, said there's limitation of damages, and even in a court of law, you've got to be bound by the AHLA rules. They didn't do that. They put that into the arbitration agreement. So if it's not severable and it's void against public policy, then there's no binding arbitration agreement.
If it's not severable, then the provisions, if the court at the trial level finds that the agreement is not severable, the remedial limitations are not severable, then that issue goes to the arbitrator to decide, as Justice Poston suggested. The arbitrator then
Wait a minute. If you find that it's not severable, what issue goes to the arbitrator?
The public policy issue.
Even you're saying, but it's the public policy that renders the arbitration agreement invalid. I would agree with you if the judge found it to be severable. Then I guess under the logic of Buckeye, that it would then go to the arbitrators to decide whether those limitations were likewise invalid. But if they find it's not severable, then they've got to look at whether those provisions are void against public policy, which will then invalidate the whole agreement. So I think you're right. That's why the threshold issue has to be severability, because if it is severable, it goes to the arbitrators. If it's not severable, it stays with the trial court to determine if there is a binding, valid arbitration agreement. I'm missing the logic the other way. Maybe I'm wrong about this, but that's how I'm seeing that this analysis has to go.
I think we just have a fundamental disagreement. My understanding is that if the court finds the agreement, the remedial limitations are not severable, then at that point, under Buckeye, then the public policy issue, the case is sent to arbitration, and under Buckeye, the public policy issue is determined by the arbitrator.
I think it backs us up to the very initial thing, is whether or not they're truly attacking an arbitration agreement which is separate from the whole contract. And on the agreements before us, it does appear that, at least without reading the complaint, that that's what they're doing, because there's an admission agreement that is separate and distinct from the binding arbitration agreement, and what they're doing, I think, is attacking the validity of the binding arbitration agreement, which is where the limitations are. And in fact, in paragraph 40 of the residence admission agreement, it says that in the event that the resident and facility binding arbitration agreement would be held invalid or inapplicable, then they would revert back to the paragraph 40 of this, which is the mediation and mandatory non-binding arbitration. So those seem like two separate agreements, and it does seem as if that they're attacking the arbitration agreement by itself, where under federal law the trial court will look at that absent the severability issues that Justice Pariente is talking about. So it does seem that they're attacking just the arbitration agreement, not the contract as a whole. So could you explain why perhaps I'm wrong on that?
Well, the issue under the first prong is the existence of the agreement to arbitrate. That is the only thing that the court is limited to inquiring about under the first prong, according to Buckeye, under the first prong in Seaford. That issue of whether the public policy, that issue of public policy, whether it invalidates the remedial limitations, does not go to contract formation. That is not a contract formation issue.
Yeah,
but does it go to the validity of the contract? Isn't the court, is it correct that the court can look at whether there is a valid arbitration agreement?
Whether it's Seaford says whether there's a valid agreement to, whether a valid agreement to arbitrate exists.
Okay.
And that is an issue of contract formation. And under that analysis, you can look at unconscionability, you can look at issues of authority, like we have in this case. The issue of whether you have remedial limitations that might offend the public policy does not go into the issue of contract formation.
So we could have, in various places, an arbitrator who says, yeah, this is void because it's against public policy, and another arbitrator saying, no, we can continue with the same kind of contract because it isn't a public policy violation. So that's what we could end up having if the trial court is not the one who would look at whether or not this contract is void for public policy reasons.
That may be true, Your Honor. We could also have the situation where the agreement, the remedial limitations never come up. We could at this point, we're speculating whether those remedial limitations will be an issue. And so that's the question. And in that case, the court will invalidate an agreement to arbitrate, will do away with the intent of the parties.
So you're saying they would do it after the fact? After arbitration determined? That the court would look at it? I thought the courts had limited ability to review the arbitrator's decision. That's why it has to be made initially to determine whether or not there's a valid arbitration agreement.
I'm sorry, was there?
No,
was there a question?
You're saying that the courts would determine after it's given to the arbitrator whether or not it violates public policy?
No. That question goes to the arbitrator.
Now, let me make sure I understand something. Why then, following your logic, why would severability be an issue that the trial court would first make?
Because it would be an issue that would be, the issue would become ripe at the trial level when a plaintiff will make the argument that there's a public policy challenge to the agreement.
But why wouldn't, under your theory, why wouldn't the arbitrator also decide severability on a public policy question? I mean, again,
because that's a question a question proper for the arbitrator, for the court at that.
But why? The only reason can be is what I think I was trying to say earlier, is that if they find it's not severable, then it goes to the entire agreement is void if the offending provisions are against public policy. Just like you admitted that unconscionability would invalidate the whole agreement, and therefore unconscionability would be for the trial court. You did agree with that?
Well, Judge,
do you agree with that unconscionability is for the trial court?
Yes, I did.
Okay, and that's because if it's if the agreement is unconscionable, then the arbitration agreement is invalid.
No, I agree that is for the trial court because it goes to an issue of contract formation.
Because if the agreement was unconscionable, then it's so. My question to you: why isn't the same issue go to that if the agreement offending provisions are illegal and there is not severable, you do not have a valid arbitration agreement?
Your Honor, the trial court has the ability to address the issue of severability. That issue is injected.
But why is? But following up on the question that's been asked, why is that an issue that relates to the making of the agreement to arbitrate, which is where the focus should be on this issue, isn't it?
Under Seifert, that's one of the prongs. That's one of the issues that the court can decide, Your Honor. Seifert doesn't address.
But I don't understand how the severability issue is an issue that is intrinsic to the issue of issues related to the making of the agreement to arbitrate.
It is not. It is not. It's a totally separate issue. It's a totally separate issue which the court can consider apart from Seifert. This court is bound by Buckeye in this case. I would ask the court to uphold the Second District Court of Appeal's decision in this case. Thank you.
You have a minute or so for rebuttal here.
How long?
A minute and 8 seconds.
May it please the court. The severance issue goes to the making of the contract because if you have to so sever the provisions out so that the essence of the agreement is gone, then the contract is no longer valid because there's no meeting of the mind.
Well, but, you know, in I guess it's Prima Paint, the contract there could have been gone if the whole agreement was fraudulently induced, the overall contract. But if I understand what happened there, the Supreme Court said that doesn't really matter. Unless there's an attack specifically on the making of the agreement to arbitrate as a separate thing, then the issue's going to go to the arbitrator. Isn't that what they decided there?
But Justice Kennedy, in this case, we have the flip side of that. Our attack is on the arbitration agreement because these provisions are in the arbitration agreement. And
well, there's no question there are some things that it's related to the arbitration agreement and is a part of it. But I think the question is does it relate to the making of the agreement to arbitrate? Basically, the agreement that the parties had that we're going to take these disputes that of whatever category covered by the agreement to arbitration.
Well, it does because not only are we going to take it to arbitration, these are the rules. If we take it to arbitration, we want to follow these rules. And if these rules are against public policy.
Well, I understand your position on that, but I don't really quite understand how that answers the question about the severance.
Because that question also goes to the making of the contract, to the essence of the contract. If you start severing out essential conditions to the arbitration contract, then in essence there's no arbitration contract left. Thank you.
All right. Thank you both for your arguments. The court will now take its morning recess for 10 minutes.
Please, guys.
Supreme Court is now recessed. Ladies and gentlemen, the Florida Supreme Court. Please be seated.
The next case on the court's calendar, Gesser versus Minor Care of Florida.
May it please the court. My name is Jim Wilkes, and I represent the petitioner. I'd like to start off by saying this is a case involving a conflict between the District Courts of Appeal involving arbitration agreement. There was an attack on the validity of an arbitration agreement at the trial level, and I had the opportunity to hear an argument and questions, so I've changed how I'm going to present this a little bit. I want to quote from the 4th District's opinion that was rendered subsequent to the Buckeye decision. It says, in Buckeye, the Supreme Court of the United States reaffirmed the principle that regardless of whether the challenge is brought in federal or state court, a challenge to the validity of the contract whole, and not specifically to the arbitration clause, must go to the arbitrator. Buckeye is also distinguishable from this case. Mrs. Bryant did not challenge the validity of the contract as a whole. Rather, she challenged specific arbitration provisions, including a limitation of liability. Thus, Buckeye is an opposite. That's what we're dealing with here. We're not attacking the fact that there was an underlying nursing home agreement, that there was a contract between the resident through a proxy and the facility. We've agreed to that. What we're attacking...
Did your case, is it also different with regard to the Florida Arbitration Code applying? Is there a provision in there that talks in terms of, except as expressly set forth herein, the provisions of the Florida Arbitration Code sets forth the statute shall govern?
Our provision was in like pages 40 through 44 of the larger agreement, and it referenced the Federal Arbitration Act, the FAA, and Florida law.
Where does it do that? Because I was under the impression, as Justice Lewis just stated, that the Florida Arbitration Code controlled. Where does it reference the Federal Arbitration Act?
I don't have the agreement. I didn't bring it up here in front of me.
Well, on the A, paragraph A1-1.1 of the arbitration provisions, it says the Florida Arbitration Code is going to control.
Then, like I said, I don't have the agreement. I recollect it said that the FAA and the Florida Arbitration Code. I don't think that's of moment here, because whichever one controls, I think we're going to have...
Well, it's better for you if it's the Florida arbitration.
It is, except when we're looking at the validity of the arbitration itself. The Supreme Court has made it clear that we're going to have to sever these out, and we have to look at two different agreements. We have to look at the contract as a whole over here, and then look separately and specifically at the arbitration.
But that's not under the Florida Arbitration Code. Doesn't operate like that. That's why Justice Parenti said, I mean, it's like you're much better off if this is the Florida Arbitration Code than the federal.
You're saying under that analysis that the analysis under federal and Florida law is the same, right? Is that what you're saying?
I thought so until I read the transcript in Renner Center. They haven't written the opinion yet. I read the Renner Center versus Jackson has been argued in front of the Supreme Court. The question there is, are post-formation acts of unconscionability to be determined by the arbitrator or by the court? That's the case.
We've already answered that. This court has answered that question.
Yes. And this court...
We take a different view than the U.S. Supreme Court.
Constantly.
You're almost arguing against yourself here, right?
No.
Talking. So
I'm trying to anticipate in case the Supreme Court comes out in a few weeks that this court can remain consistent with its position as it always has and be consistent with the Supreme Court.
So the U.S. Supreme Court, because I'm not aware of this case, says they're looking at whether even an issue of unconscionability would be for the arbitrators to decide?
Right. There was an argument April 7th, I think, Renner Center versus Jackson. And what the court got right, the Supreme Court got right there, was that it's state law that determines the making, even under the Federal Arbitration Act, it's state law that determines, if you're dealing with a state contract, whether there was a valid contract in the first place.
Well, let's go to that issue, which is that do you agree that that the first issue to look at is probably the offending provisions are severable or not?
I think the first thing is you look at are there offending provisions? Well,
and
then once they're provisions, you look to see if they're severable. And the 4th District answered that.
Well, let me just stop you there. Because if they are severable, whatever those are, then the arbitration agreement is not invalid. It's only if they're not severable that the arbitration agreement is invalid.
I would agree with that as a general principle of arbitration. I think we may have special issues with Chapter 400 nursing home residents, but I agree with you. That's the correct principle, that if they're severable, that the trial court would sever the offending provisions and send the matter to arbitration.
Or just decide that they're severable under the theory that then the whole arbitration agreement is not invalid, and even send the issue of whether the offending agreements are invalid to the arbitrator. It's not that that's something that I would agree with, but that seems to be, at least under Buckeye, what might have to happen.
That's what happened in Altura versus Bryant, where there was a severability clause, and the 4th District came out.
Now, in this case, there is no severability.
There's not one, and there's cases directly on point involving the same contract. Lacey versus Healthcare Retirement Corporation's a Manicare case. Out of the 4th District, and they stated that regarding this same contract, the instant agreement is titled an arbitration liability agreement. The title alone suggests the offensive limitations of liability go to the essence of the contract. In this case, the limitations were incorporated by reference into the contract. So under Lacey, in the absence of a severability clause, this case is much simpler to answer, that it does include the provisions that violate public policy, and therefore no valid contract was made. And under Seifert, the Florida law is very controlling and states that you have to have the knowing waiver.
Is there a difference between something being void or voidable?
Yes. Voidable is option.
I mean, in other words, going to, and you heard the last argument, is there an argument to be made that, first of all, that unconscionability should be treated as one of the contract formation, but whether a provision is void as against public policy occurs after assuming there's a valid agreement to begin with?
There's a difference between post-formation unconscionability and formation, unconscionability in the formation. Generally, courts seem to call unconscionability in the formation of a contract void as against public policy.
Well, that dichotomy between void and voidable was expressly rejected by the U.S. Supreme Court, wasn't it?
Not in this context.
In the Buckeye case?
No, sir. Not in the context of. It was in the context of whether you look at the bigger contract or the little contract. The void and voidable, a minor can void a contract. It's merely voidable. There's not necessarily something inherently offensive in a voidable contract. There's an inherent offensiveness in a void contract. And what the Supreme Court was saying was whether the underlying contract itself is void or voidable. They said it doesn't matter if it's criminally usurious. We don't care that the entire agreement can be a sham, but if the arbitration agreement is there, that the court has to look just at the arbitration agreement and then let the arbitrator look at the big contract. I think as Justice Kennedy said in Renner Center, the law is upside down. But regardless, that's law. But where they were talking about the void and voidable doesn't matter is in the examination by the state court. And they said in Buckeye, it didn't matter whether it was criminally usurious and void or voidable. You still can only look at the arbitration agreement. These cases today, this case here, the Augusta case, we're looking just at the arbitration agreement, and we're not looking at the contract.
Well, why is it that in this case where there are no shifting standards of proof, why isn't it that if you take out the limitation of liability and the punitive damages, that there's still not a valid arbitration provision?
Because as the Lacey Court says, the agreement suggests that the limitations on liability go to the S of the agreement.
Well, they could say that. And again, my sympathies are where Judge Altenburns are about these kinds of provisions and having arbitrators have to, whether they decide it or not. But I'm trying to decide on the issue of if there's not an unconscionability question, which has not been preserved here, that just on the issue of void as against public policy, that the legislature could say there shall be no provisions in arbitration agreements that limit liability, why would that void an entire arbitration agreement to arbitrate?
Because it's the Supreme Court's role to set public policy in Florida. Going back long before law school, Marbury versus Madison, we determined that our courts would set public policy, not our executive branch and not our legislative branch. Public policy is set, judicial public policy is set by the Supreme Court.
But aren't there two public policies? One is that we wouldn't want to limit the damages where the legislature has already said that those damages are necessary to protect our most vulnerable citizens. But in this state, still, we have a presumption in favor of arbitration. And so why isn't the idea of severing the offending portion and allowing arbitration to go forth meeting both public policy goals, which is not limiting the liability, but accepting the choice, the forum choice, if the agreement is not otherwise unconscionable?
Because in this instance, the waiver is one of a constitutional right, a protected right under remedial statute.
The waiver of a right to jury trial?
The waiver of the right to damages that are recoverable under access to courts.
But I just gave you the scenario where you'd get the damages. You just would get them in a forum that is not the preferable forum for plaintiffs, which is an arbitration forum.
Judge Northcutt asked this question, and his
the same exact question. He talked now.
He said the Florida Supreme Court encapsulated the three questions a court must answer when faced with a motion to compel arbitration. 1, whether a valid written agreement to arbitrate exists. 2, whether an arbitrable issue exists. And 3, whether the right to arbitration was waived. Resolution of these matters is a matter of contract interpretation. In this instance, the court found that these provisions were against public policy and would void the contract. It's not to the court where there's no severance agreement for the court to go back and reform or fix the agreement. We're dealing with more than just substantive unconscionability. We're dealing with incredible procedural unconscionability as a matter of the nature of the relationship between the resident and the facility.
But that's not before us in this case.
No, but in this case, what is before us is this contract that contained the offensive provisions had already been stricken down. This very company, had already had its provisions in 2001 in Romano stricken, and they were still presenting these years later to the residents to sign and hoping that the courts would come in and give them the relief. That's why it's void against public policy.
Help me understand the relationship here between the limitation of liability provision and the arbitration provision. Now, I understand that at the end of the arbitration provision it says that the limitation of liability is incorporated, but they do seem to be addressing two different things. And so I'm having trouble if we were, and maybe we're not, but if we were working within a framework, the framework established by Buckeye, this seems maybe a little different than the case we all just heard about, where the provisions that were argued to be against public policy were really maybe integral to the whole arbitration process that was agreed to. Maybe that's different than something where we have really a separate, connected, but separate limitation of liability provision. The attack here is on that. I don't see how it is in any way on the making of the agreement to arbitrate. But tell me why I'm wrong.
Because it says they're incorporated by reference. And just as if they had attached an appendix and said it's incorporated by reference, they stuck these things on that the courts of appeals had been telling them are unconscionable and against public policy and void. They stuck those limitations in there and said we incorporate these by reference into the arbitration section of this agreement. And now that we have Buckeye, we don't have to look at the whole agreement and say the whole agreement's invalid. In this case, it makes it a little simpler. We're looking at the arbitration agreement. We have an actor over here that knew what they were doing was against public policy. They continued to do it after the courts had told them don't do it. And now they're asking for relief, and they're asking the court to reform their misconduct. And that's where the problem lies. And I don't want to take up all.
The question is those two provisions here seem like the kind of provisions that you could say these are not enforceable provisions, and yet then send the case to arbitration without those provisions, and that is you would not have that limitation on the non-economic damages or the limitation on the. So why isn't that the way to do that?
You could, but we've got 70,000 nursing home residents who face these, and every time they're going to have to get a lawyer and have somebody go back and go to court and ask the court. The whole point of this, and this is what Judge Altenburn is so frustrated about, this is supposed to be efficient. We're going to end up for the next 20 years continuing for this court, for the district courts and the trial courts to reform these contracts. That's why nursing homes, as important as it is to look at arbitration globally and how it affects business and interstate commerce, we do have a special role here with nursing home residents.
And you have used some of her rebuttal time.
Thank you.
All right.
May it please the court, my name is Matt Canigliaro. I'm with Carlton Fields, and I'm here today on behalf of Manor Care and its affiliates.
Could we just get a couple of things squared away so we know what we're really talking about? Number one, is counsel correct that this limitation of liability has been stricken with regard to this particular defendant in some prior cases?
There were cases in the mid-2000s out of the 4th DCA and the 3rd DCA where similar agreements involving similar limitations were found to be
the same
unconscionable. I'm sorry?
Party?
A related party. I'm not sure it was the exact same Manor Care entity, but a related entity.
This issue about the Florida Arbitration Code and whether the Federal Arbitration Code controls.
I'd be very happy to address that. In this case, the Federal Arbitration Act controls. The language that Justice Polston pointed out earlier, referring to except as expressly set forth here in the provisions of the Florida Arbitration Code shall govern the arbitration.
Right.
First of all, it provides shall govern the arbitration. We've still never gotten to the arbitration. Second of all, that language does not change the application of the Federal Arbitration Act. In the U.S. Supreme Court's decision in Volt, they were dealing with a similar provision that made the local law control. And the U.S. Supreme Court explained that merely choosing perhaps the procedural rules of some state or another does not change the application of the Federal Arbitration Act. In this case, the Federal Arbitration Act...
I'm sorry. I'm not so sure I can read it in the same way with you. The question's going to come down as to whether the Federal Arbitration Act is controlling.
And our answer to that, Your Honor, is yes.
Why. Is it and why?
It is for multiple reasons.
All right.
First of all, the test under the Federal Arbitration Act is whether there is a connection to interstate commerce. There is a connection in this case to interstate commerce. We have said that since the initial hearing.
Right.
The other side in this case, not in the trial court, not in the 2nd DCA, and not in this court, has never challenged that the Federal Arbitration Act controls. They have agreed it controls throughout this litigation.
Okay. And you're telling us that there is a United States Supreme Court case that says if I have a contract to arbitrate that says the Florida Arbitration Code shall control, that still the Federal Arbitration Code prevails. Is that what you're saying to us?
Yes, Your Honor,
okay.
And I'll add that here it says shall govern the arbitration. And here we've never gotten to the arbitration.
We're at Volt, where it said that the law of California is going to control. There was a lot of discussion in that case about whether there was going to be, whether the choice of law provision in there really was a choice of arbitration law. Nevertheless, the California state courts determined that that's the way it was going to be interpreted, that the California arbitration law controlled the situation, and they actually applied California arbitration provisions, did they not?
As I recall the Volt case, the U.S. Supreme Court applied the Federal Arbitration Act throughout the decision.
Well, if there is one thing that seems to me applicable to arbitration law generally, is that the contract language itself is going to control. And everything, whether it's federal or state law, is going to be governed trying to enforce what the parties have agreed to.
I would agree with that, Your Honor, and I would emphasize that here, both sides throughout this litigation from the trial court through today have agreed that the Federal Arbitration Act controls. We've simply disagreed on how to apply that. And I'll add to that we would urge the court that there is ultimately no difference on the merits of what the law provides.
Let me move you to the severance provision. Here, the district court actually severed a provision when there was no severance express language in the contract.
Yes, Your Honor.
Why should we do that? Why should we say that that is a legally permissible thing to do?
Florida law has never required parties to include a severance provision in their contract in order for a court to sever out an impermissible term. What Florida law has long provided is that when impermissible terms are removed, there is still an enforceable agreement. And if the parties didn't intend that they would only agree to those impermissible provisions, then the court can sever. In this case, neither side has ever taken the position that they would not have agreed to this agreement without these limitations on remedies, and we've never taken the position that we would not have agreed to this agreement without these limitations on remedies.
What concerns me is that it seems like that provides a ripe opportunity for courts to start rewriting contracts by severing provisions out of there based upon void as against public policy and having results that are totally different than what anybody really intended. That's a major concern of mine.
Your Honor, I think perhaps in some situations there could be a concern there. I don't think that's a concern in this case. Neither party is suggesting that without these limitations we would never have agreed to arbitrate. That is the position of neither side. But I would emphasize that under both the Federal Arbitration Act and the Florida Arbitration Code, the issue, the challenge that the plaintiff has brought to these remedial limitations is for the arbitrator.
Well, let's go so on that issue. If it's not severable, how is that? And if it's not severable, then the issue of whether if it's void against public policy and it's not severable, doesn't that make the arbitration agreement void, invalid?
No, and I want to be really careful how I answer this. We have two arguments why we believe the issue is for the arbitrator, not for the court. The first argument is that the test under the Florida Arbitration Code and the test under the Federal Arbitration Act is actually the same. It's whether or not a challenge has been brought to the making of the arbitration agreement. That, in a nutshell, that's the first argument we present the court with. And that's the first argument that the DCA back in the Rollins decision agreed with. There's a second argument. I won't say that it's not related at all, but it is independent. And that's that if the challenge provisions are severable, then you don't have a challenge to the validity of the agreement.
I think I agreed with you on that. In other words, severability is a threshold issue. If it's not severable, then the whole agreement is invalid. If it's severable, then theoretically an arbitrator could make the decision, although on these provisions, which are eliminating statutory rights by limiting damages and punitive damages, the nursing home has essentially thumbed its nose at the Florida legislature, and I would think that, I'm trying to think of an arbitrator in light of the law in the state of Florida that could find the provision not to be void as against public policy. So I guess I'm asking two things. One is, if it's not severable, and I thought you said you want to be careful, but if it's not severable, then the judge needs to make the decision if that provision is invalid or not. If it's valid, then it goes to arbitration. If it's invalid or void, then the whole agreement is void, because that's what the severability has to do with.
And there, Your Honor, I would respectfully disagree. That we have cited a series of cases, some 10 or 11 cases from around the country, that each of them held, and I'll quote from the Supreme Court of South Carolina, "The question of whether the clause preventing punitive damages violates public policy is not yet ripe because an arbitrator has not ruled on the issue."
Did they deal with severability?
They weren't dealing with severability, and that's
what
actually...
I'm asking you, though, because you agree the severability is for the judge, the trial court to decide.
Under one of our arguments, severability is a threshold issue, that if the provisions are severable, we just go straight to the arbitrator.
Okay, so you both, and your counsel in the prior case, agreed that severability is for the trial court. If it's not severable, then under what theory of logic, common sense, would tell you that the policies underlying the Federal Arbitration Act, the Florida Arbitration Act, would have that threshold issue, that is, whether the entire agreement is invalid, would go to the arbitrator and not be decided by the trial judge.
I'll answer that by quoting the Seventh Circuit. Because the adequacy of arbitration remedies has nothing to do with whether the parties agreed to arbitrate, these challenges must first be considered by the arbitrator. And this goes back to the language in both.
But it does sound like, again, I'd have to read that Seventh Circuit case, that they weren't dealing with severability. You'd be right if a trial court found it was severable.
And let me try to explain why that's the case, Your Honor. In all those cases that I believe we've cited on those pages of our brief, none of them dealt with severability. And that's because these are two distinct arguments. Under the Florida Arbitration Code, if the court is satisfied that no substantial issue exists as to the making of the agreement, it shall grant the application. Under the Federal Arbitration Act, upon being satisfied that the making of the agreement for arbitration is not an issue, the court shall make an order directing the parties to arbitration. It's the threshold question on this argument is whether or not the challenge has been brought to the making of an agreement. And do we have that here? And the answer is we don't. We don't because the challenge here goes to remedial limitations, not whether the parties made an agreement. It's a challenge to the terms of the agreement that the parties made. And in that set of cases, and this is, I think, consistent with questions that Justice Kennedy was asking earlier, the issue is to look at whether or not the challenge goes to the making of the agreement. And I'd like to go back to Seifert and its reference to validity and how that interplays with Buckeye.
If validity were in the contract, it would be a lot simpler case, wouldn't it? I mean, if the validity of the contract were actually in the arbitration agreement in the scope, then that certainly would be a matter for the arbitration panel to consider, not the court, and that would be clear.
I'm not sure I follow, Your Honor.
Well, in the Buckeye case, in the express language of the arbitration agreement, it specifically said the validity of the agreement would be considered by the arbitration panel. There's not a similar type reference in this arbitration agreement.
That's true, Your Honor. There's not a reference to that in this arbitration agreement. However, under both the Florida Act and the Federal Act, the threshold issue with the court is whether or not there's been a challenge to the making of an agreement. And what constitutes the making of an agreement? Well, here it's the provision at the beginning of the arbitration agreement that says, any and all claims or controversies relating to the parties shall be heard by an arbitrator. A challenge to the making of that agreement would be an argument such as, I didn't sign this, or I wasn't competent to sign it.
Or it was unconscionable.
I wasn't authorized to sign it. I'm going to respectfully disagree on unconscionability. It's not an issue in this case, Your Honor, in GESA. There's no unconscionability issue before this court. There was one in the trial court. It was dropped by GESA at the DCA
we're asking
level.
We're here on conflict issues and broader questions. I'm asking you if within your the other issues you brought up were not within contract formation. So, or are not issues in the case, such as whether there's fraud in the inducement. So I'm saying, is unconscionability like one of those?
And I think unconscionability is, historically, a lot of cases say that unconscionability is an issue for the court as a threshold matter. As has been discussed already, there is a case pending at the U.S. Supreme Court where a decision is expected in the next couple of weeks that deals with an unconscionability challenge to something that doesn't go to formation of the contract. And everyone is, the parties are sort of waiting on what will come from that. I suspect that what will come from that will be a decision that makes the answer to Your Honor's question maybe. That it will depend on what is supposedly unconscionable. It's sort of like public policy. Our argument is not that all public policy challenges go to the arbitrator. Our argument is that you have to look at what is being challenged. And is it a public policy challenge to the making of an arbitration agreement? Here, it's not, because the challenge goes to the remedies, not to the formation of the agreement, not to the making of the agreement. In another case, you might argue that it's against public policy in Florida to arbitrate these types of disputes. That would be a challenge that goes to the making of the agreement. So I want to be careful not to answer categorically one way or the other.
Well, let me ask you again, the question again about severability. I'm still trying to grapple with how severability goes to the making of the agreement. Am I correct in understanding that your argument about severability is kind of a fallback argument, or am I missing something there?
It's one of two arguments. I think the answer is that if the provision is not, well, if the provision is severable, then it's easy to see that this is not an attack.
But what if it's not severable? I mean, you can't say it's an issue for the court if it's severable, but if it one way, but it's not an issue for the court if it's the other way. Well, I mean, it seems like you've got to have the or if you can, help me understand why that would be so.
And I think here's the answer, Your Honor. If the ultimate question under the both acts is, does it go to the making of the agreements? Right. Seifert, in its three-part test in the first prong, used the term validity. We should examine whether there is a valid agreement to arbitrate. And that, I would suggest, was a paraphrase of both the Federal Act and the State Act. And it's a helpful paraphrase, but it has some limits on it. It doesn't always work. And what happened in the Buckeye case that came through the Supreme Court of Florida was an example of where it didn't work. This court looked to validity as a matter of Florida law, and the U.S. Supreme Court said that's not correct. You can't look at the validity of the entire agreement. You must look at the arbitration clause. What is the arbitration clause? Well, reading Prima Paint and reading Buckeye and the series of cases that we've cited to the court, the arbitration clause, the making of the arbitration agreement, is the language where the parties agree to arbitrate. Other items, such as the remedies available in arbitration or maybe perhaps other concerns that are related to arbitration, don't go to the making of it. So it does sort of work one way.
I find it disingenuous an argument that says these are part of the arbitration agreement, and then to parse out and say, well, those really aren't part of it. I mean, to me, it's just talky talk. I mean, my goodness, it says in here, does it not say that all these limitations are part of the arbitration agreement?
Yes, Your Honor, it does, and we're not disagreeing.
That, and then we start saying, well, that's not really part of the arbitration agreement. I don't know how to make of these arguments. To me, this thing just keeps chasing its tail. And I'm trying to understand it, but I'm not being helped with
and
this.
I'll do my best to help, Your Honor. Where some of the confusion comes from here is what is meant by the arbitration clause itself. Is it the greater arbitration agreement? If two people enter an arbitration agreement and include lots and lots and lots of terms, does every one of those terms constitute the arbitration clause?
Part of the arbitration agreement, that makes sense to me. And common sense that somebody in the public could say, yes, this is part of the arbitration agreement when the agreement says that.
Under the gateway issues tests of the Federal Act and the Florida Act, though, we would disagree that while to a layperson on the street, yes, this is part of an agreement, for purposes of the Act, when it makes the policy decision that we favor arbitration, unless the challenge goes to the making of the arbitration clause.
Well, then that just means the clause, the sentence, we agree to arbitrate. We'll parse everything else out. We agree to arbitrate. That's the only clause.
And where's the consideration for that? I mean, and where's the case law that even remotely suggests that it's only the one sentence, I agree to arbitrate, that is the only issue that should be considered? I mean, I'm hearing that argument. I mean, in all due respect, maybe you've made it in your briefs, which I read, and the brief is excellent, but I think that is really parsing something that's never been parsed before.
Your Honor, we're not saying that it's just the single sentence, and I'm not sure where the line is. In this case, we haven't had to try to draw it, except to say that remedial limits are outside it. And we've cited almost a dozen cases from around the country that address that issue.
If the legislature said that any agreement to arbitrate that contains a limitation of liability shall be void, who would decide what the legislature meant by that?
The arbitrator. Because if the challenge is brought to the remedial limitations in an agreement, it is not a challenge to the making of the agreement. And that's what the Seventh Circuit has said.
Can you explain, and maybe the U.S. Supreme Court has explained it well, by what logic that would be an important public policy of the state of Florida that eviscerates a remedial statute would be one that would be secret and made by arbitrators that might invalidate a whole agreement. Explain the policy of this state or the Arbitration Act that would say that's who should that's the group that should decide a threshold question of whether a whole agreement is void.
The policy behind it is the federal policy that in Moses Cone, in many cases since, the U.S. Supreme Court has said all courts must give a healthy regard to the federal policy favoring arbitration. It's that
but
when
not
the parties,
arbitration of agreements that are void against public policy. Isn't that why it's a threshold issue? Because if an agreement is void as against public policy, then there is no, then the person who's made that agreement does not get the benefit of limiting the decision to an arbitrator. That's the reason.
Well, I think we would disagree, Your Honor, that the remedial limitations, which are what are at issue in this case, are separate from the arbitration clause itself, where the parties have agreed to arbitrate their disputes, and where the challenge goes to, as here, just the remedial limitations. That's not a challenge to the making of the agreement. And that is the first argument. The second argument that we've made is based on severability, that these provisions are severable for reasons that have already been discussed here today. And we would ask this Court to follow the Second District and approve the Second District's opinion, the federal cases that are cited in Rollins and its progeny, and to agree also with the 11th Circuit's decision in Anders regarding severability. Those are two separate lines of argument. They've both been applied by the Second DCA, and we ask this Court to affirm those decisions, approve those decisions. Thank you.
Rebuttal.
May it please the Court, my name is Susan Morrison. I'm co-counsel along with Mr. Wilkes for Angela Gessa. And Chief Justice Quince, can you tell me how many minutes we have left?
4.5.
4.5. To address one of the issues that was raised by Justice Lewis and also Justice Polson with regard to application of the FAA, I have to apologize to the Court and to Mr. Wilkes. Sometimes when you have two cases back-to-back, we were counsel in both the Schatz case and this case, and I mixed up the facts. FAA was the Schatz decision, and I whispered to Mr. Wilkes just before he got up that FAA applied in this one, and I was incorrect, and I apologize for that. With regard to counsel's comment that we conceded in the trial court and in the appellate court that the FAA applied, we did not. If we cited cases, and in fact we were criticized for not even making reference to either Prima Paint or Buckeye in our initial brief, we did bring it up in the reply brief to explain that even under those federal cases, that the law is consistent insofar as both Prima Paint and Buckeye said you look at the arbitration provisions separately from the underlying contract. And in response to Justice Kennedy's query earlier, I think that the language that you referenced with regard to if you're attacking an illegal provision in the contract goes not to the severed arbitration agreement, but if you're looking at, for example, the usurious illegal provision in the underlying contract, that would be something for the arbitrator to decide. But in cases...
Well, but I don't really understand why that would be so, because if the focus is on the making of the agreement to arbitrate, because if I understand it correctly, what they're getting at there is that cases should not go off to an arbitrator if the parties didn't agree to arbitrate.
That's exactly right, Your Honor.
Okay,
and
that's what it's about. But
attacked.
that's not what's at issue here. It's not an issue whether the parties agreed to arbitrate the case. The question is whether there's this other provision that invalidates the whole agreement.
We would respectfully disagree, Your Honor, and I'll tell you why. Under Seifert, the issue, the validity issue that was referenced by both counsel goes to, and I'll quote the court, the voluntariness of the agreement, the knowledge of the parties, the bargaining power of the parties. Seifert was looking at all of the totality of circumstances and said it goes to the formation of the contract. Similarly, and Mr. Wilkes brought up the rent-a-center oral argument last month before the Florida Supreme Court.
Maybe that's related to unconscionability. That's a different issue, though. But we're not dealing with that here in this case, are we?
Well, we take the position that there was no meeting of the minds. You have to have assent in order to have a contract. And when a party of unequal bargaining power slips in things that do go beyond, far beyond, the remedy provision. For example, If you can't bring a punitive damage claim, then you can't put on in your case in chief any evidence of prior bad acts, any evidence of motive of putting profits over the care of residents. It changes your case completely.
Is meeting of the minds mentioned in the second DCA opinion? Is that an issue in the case?
No, Your Honor. I'm just bringing it out from the Seifert case because Seifert basically says when the court is doing its duty under the first prong of Seifert to determine the validity of a contract, it has to look at things such as voluntariliness, knowledge, the scope of the consent to arbitrate, and the like.
Did the second district and the trial court essentially agree that this provision was a void against public policy?
No, Your Honor, and that was a very frustrating thing for us because under the first prong of Seifert, the Linton court in the first DCA said the court not only has the authority to decide validity of the arbitration agreement, it has the duty to do so. And the second district in 4 cases now has said, well, we think it might be against public policy, but we're not going to decide that. And we think it's severable, but we're not going to sever. So we take the position that they really did not discharge their duty under the first prong of Seifert in making that determination of validity.
So if we agree with you that it should be not severed, what should we do? Send it back to the DCA?
Your Honor, we believe that it's not severable for an issue that hasn't been raised yet, and that is the district courts of appeal have differentiated between cases that have severability clauses, the cases that don't have severability clauses. But the precedent from this court in the local 234 case says it doesn't really go to the issue of whether that provision is in the contract or not. It goes to the intention of the parties, and the intention of the parties is determined by the court looking at the circumstances of execution of the contract and of the terms itself. And in the GESA contract, the fact that we didn't have a severability clause is an indicia of the intention that we did not intend for the provisions to be severed, and the fact that we incorporated those remedies by reference into the arbitration agreement is another indicia that we did not intend to sever these things out.
Paulson's question, though, was if we assume it's not severable, then what happens?
Then the court has to, under the first prong of Seifert, determine that it's void.
Well, the DCA did not reach that issue, so shouldn't we send it back to them?
You can do that, Your Honor, with instructions that they make that determination, that it's the duty of the trial court under the first prong of Seifert to determine the validity of the contract.
Won't that bring us right back up here if, in this case, because every other district court has said that this is a void provision. So to send it back for them to perhaps make a different decision just puts us back in conflict.
Well, this is a de novo review situation, Your Honors, because it's an interpretation of a contract was purely a matter of law, and this court can decide that under circumstances such as these, that these contracts should not be parsed.
But it hasn't. What I'm asking you, aren't there exact cases on point from all the other district courts that say these are void against public policy?
Yes, there are. Second District is the only one who not only didn't say that, but wouldn't rule on the issue. And there are cases, legion cases from this court that say, and all of the cases, most of the cases cited by counsel in his brief from other states and other federal districts were not remedial statutes. Remedial statutes are treated differently. There are public policy concerns. This court, as early as 1998 in the Green v. Life and Health America case, said parties are free to contract away their rights, but not their rights under, or their remedial rights under a public policy statute. And that's what we have here, and that's why we asked this court to determine that the contract is void in its entirety and bring some clarity to the law in this issue, because we're before the district courts weekly almost on these issues, and the cases are all over the place. The frustration expressed by Judge Altenburn was also repeated by Judge Northcutt in the Stour case and by Judge Farmer in the Blankfield case. It's frustrating. I don't agree, nor does petitioner agree, that it's for the legislature to enact policy. The legislature already did that. In the preamble to the statute, they said, we know that this body of people need protection and that this industry, despite their good faith, are not self-policing. So they've already enacted a statute which protects these folks, and it's up to this court to ensure that those rights are protected. One last point.
Well, thank you very much. You have well exceeded your time. Thank you.
Sorry.
And I thank all of you for your arguments here today. The last case on the court's agenda today is State versus Cable. Ms. Dunleavy?
Thank you, Your Honor. May it please the court, I'm representing...
And please use the mic and speak into it.
I'm sorry.
You can pull it down some.
You can adjust.
Yes. Okay.
Is this any better?
Yes. And just speak directly into it.
May it please the court, I'm representing the state on this petition for review based on a certified question out of the 2nd District, and the question they certified was, in view of the abrogation of the exclusionary rule for Fourth Amendment knock-and-announce violations, should the judicial remedy of exclusion of evidence be applied for violations of Florida's statutory knock-and-announce provisions?
Well, let me ask you it this way. If Benefeld, we're looking at whether Benefeld should be receded from, correct? The Benefeld has been the law, and it says that if there's a violation of the knock-and-announce, then there were extreme circumstances there, but if there's a violation, then I read it to say that because of violation of the statute, that there shall be exclusion of the evidence. So the decision in Benefeld is not based on the Fourth Amendment. Accepting that is true, then Hudson doesn't change Benefeld. So why should we recede from Benefeld?
I think you should recede from Benefeld because we have a constitutional provision now that has been amended in the Florida Constitution since Benefeld issued, and that limited search and seizure protections to whatever.
I understand that, but I'm asking. But Benefeld was not based on the Fourth Amendment. That's what I'm going. It's based on a statute that the legislature passed that has not been amended since Benefeld. And so, for what reason should we recede from Benefeld?
The statute does not provide a remedy of exclusion of evidence, and it never has. And this court has fairly recently held in the Jenkins case specifically that where you have a violation of a statutory provision, unless the remedy of exclusion of evidence is expressly provided in the statute or there's a constitutional violation, then the defendant is not entitled.
So you would say that Benefeld is now essentially in conflict with the reasoning of Jenkins? Is that, I'm trying to, are you relying, because it seems to me Jenkins does to some extent change the legal landscape. I didn't agree with Jenkins, but that's what we decided. And so are you saying that because of Jenkins, not because of Hudson,
well,
that
because of the sequence of events starting with the amendment of Article 1, Section 12 of the Florida Constitution, followed by the Hudson decision, which said for Fourth Amendment violations, you can't, of a no-knock or a knock-and-announce statute, you can't get exclusion of evidence. And then we have the Jenkins decision that says, unless there's a constitutional violation or the statute expressly provides for exclusion as a remedy.
The statute expressly providing. In Jenkins, the statute did expressly provide for some kind of remedies. It just was not exclusion of the evidence. Is that correct?
I believe so, Your Honor.
Now, in this statute, what is troubling to me is that there doesn't seem to be any kind of remedy in this statute about knock and announce. Is that correct, or is there some remedy I'm missing?
No, Justice Quince, you're correct as far as the statute does not expressly mention any remedies. That does not mean, however, that there are no remedies.
So, and Jenkins, you know, since we had remedies were expressed, we were not adding a remedy to the statute. In this statute, there are no remedies that are expressed in the statute. So my concern really is that, you know, why would any police officer ever abide by this statute?
Because
let me finish the question. What would be the remedies, and why shouldn't we say, until such time as the legislature may want to put something there, that a remedy that is available is, in fact, exclusion of the evidence?
Well, for two reasons, Your Honor. One is that there are civil remedies. The Hudson case discusses those in detail.
And what are the civil remedies available for violation of this knock and announce statute?
Because it is a constitutional violation, even though, or a Fourth Amendment violation, even though it doesn't entitle you to suppression, someone could bring a 1983 action. That's discussed in Hudson, and you also have the aggrieved person has the right to make an official complaint to the law enforcement agency, which these days generally takes such complaints seriously, conducts internal affairs investigations, and disciplines any officer who has acted improperly, retrains its people to make sure that this sort of thing doesn't happen again, and that sort of thing. The other reason is the knock and announce statute, and going back to its common law roots, was never intended to protect a person's interest in the government not finding or seizing evidence. There are basically three interests that Hudson goes into. One is concern that there could be violence if law enforcement goes barging in without announcing their authority, because the people inside are afraid they're being attacked by unknown intruders and may act in self-defense. People could get hurt. That's one. The second one is, with forcible entry, there can be destruction of property. If the knock and announce statute is complied with, then the person inside has the opportunity to answer the door before the forcible damage to the door or the door frame or windows or whatever is done. And the third is basically to protect the dignity of the people inside, give them an opportunity to get dressed. You've got to wait some reasonable amount of time for either admission or refusal to admit the officer.
Is there any room in this as another reason that police deterrent of police misconduct?
I agree with the reasoning of the Hudson case that it's not a viable reason for deterrence of police conduct. It doesn't really serve that purpose too well, because very often, by the nature of the knock and announce, there's some vagueness built in. It doesn't say specifically how much time you have to wait before you enter, and things like that. And there can be exigent circumstances that might excuse full compliance with the knock and announce statute. And here we did have.
Those are the kinds of things that you discuss, and when a motion to suppress is filed and these issues come before the court.
And in fact, in this case, that was discussed.
But then you get to the extreme cases like the Benefield case itself, and so you know it seems to me that under those kind of circumstances, certainly there needs to be something more than a slap on the wrist to the police officer that no, this was bad conduct.
Well, Justice Quince, I don't believe that, the conduct in the Benefield case was truly egregious, and I don't believe that a law enforcement officer who did that now without any kind of justification would simply get a slap on the wrist. With civil remedies, the municipality or whatever agency it is can get slapped with a hefty judgment, and that is certainly an incentive for law enforcement officers to comply with the knock and announce statute, because otherwise their agency is going to have to pay big bucks, and nobody's going to be happy with them. They're most likely going to lose their job and probably would have difficulty getting another law enforcement job anywhere else.
Well, let's talk about whether there's any room for besides an all or nothing, which is, it seems that you're arguing, and I understand your arguments, that Benefield no longer, based on the three developments, is viable. But if we say that if Benefield was extreme circumstances, there was no search warrant, no arrest warrant, no announcing, no knocking, barging in, forcible entry, whatever else they did, destruction of property. Here, you've got a situation, you would argue, and the judge found, where there was a knock, there was announcing that it was the sheriff or police. They opened the door. It was to a motel, not, whether that's different from a home, and that the defendant was sleeping at the time, and so presumably under the way we decided GM, even if they announced their purpose, she wouldn't have heard it anyway because she was asleep. So is there any room for a rule of law that says, well, this case is not like Benefield, and this should be on a case-by-case basis, and has considered that other position, and how would you apply it?
Well, I
and am I correct about that? That the facts as found, or what I said, which is that there was announcing his authority.
All of your statements about the facts in this case are correct.
Opening up, not a barging in, and that she was asleep. Was she asleep?
Yes, Your Honor. So, apparently she was at the time that he actually entered.
So presumably, even if he said, my purpose is to serve a warrant, she was asleep. She wouldn't have heard it.
Presumably, although her son had apparently been attempting for more than 10 or 15 minutes to wake her up. I wouldn't advocate a case-by-case application of the exclusionary rule. Now, Benefield, I think is...
But isn't unreasonableness of a search or seizure part of what you look at when you're looking at the Fourth Amendment? So why wouldn't that be part and parcel of what you'd look at for a statutory violation?
Well, it would be. But there's no problem with the reasonableness of the search done in this case. First of all, there was a warrant.
I asked you, is there room then to keep Benefield, but to still say, in this case, the remedy of exclusion is not appropriate?
Well, I think that Benefield and Jenkins would not be inconsistent in a situation where if they don't have probable cause and they don't have a warrant, that's a different situation.
Well, if they don't have probable cause, then we'd be there in a Fourth Amendment violation. They wouldn't need the statute. If there's no probable cause to enter, there's a threshold Fourth Amendment issue, even under the U.S. Constitution.
Right.
I don't think they've yet allowed.
Right. You have to have probable cause to enter. Yeah. So I think if there is another if there's a constitutional violation other than simply a technical violation of knock and announce, then Benefield would still be applicable. Exclusion of the evidence would still be applicable because Jenkins recognizes if there's a constitutional violation. Here, it gets kind of a little bit confusing because we do have a Fourth Amendment violation, but it's one that the U.S. Supreme Court has said does not justify suppression of evidence. And so it's tantamount to not a constitutional violation within the context of can we apply the exclusionary rule for simply a technical violation of the knock and announce statute. And here, at best, it was a technical violation because he did knock, he did announce his authority, but although not his purpose, and then he did wait a very reasonable amount of time before he actually entered, and then because the door was unlocked, there was no...
Let me ask you, what about a situation, would your argument still be the same in a situation where there was no knock, no announce of any presence or authority, just nothing, and we still would not have an exclusion of the evidence under those circumstances? Or do we get back to, under those circumstances, we have a pure Fourth Amendment violation? If there's no compliance at all with the knock and announce statute.
Well, we do have a Fourth Amendment violation, and we also have a violation of the sanctity of the home under the knock and announce statute. The state's position would be that the exclusion of evidence, because the knock and announce statute was never intended to protect people from being arrested pursuant to a warrant or from having the state discover evidence of a crime and seize it, that the civil remedies that are in fact available are sufficient. There are substantial monetary penalties depending on how egregious the situation is that would be a deterrent.
So your answer to the question is still the exclusion of evidence would not be the remedy?
Unless the legislature were to amend the statute. I mean, the legislature could do that.
My question would be, why in this situation wouldn't it be the opposite, which is Benefeld's on the, and again, I'm really up in the air on this in terms of where to go. I think there's good arguments on both sides, but on the argument of that Benefeld has been the law, it remained the law after Hudson, and that therefore, if it's going to be changed, it should be the legislature that changes it by being explicit as to what the remedy would be, and that exclusion wouldn't be the remedy. I mean, that would be consistent with precedent and stability of the law, and give due deference to the legislature, who has not seen fit to amend the statute in the last 30 or 40 years.
Well, the legislature didn't amend the statute because the courts imposed whatever remedies were sought, but the legislature simply wanted to codify the common law to protect the sanctity of the home. And that's why the knock and announce statute contains the provisions that it does. The legislature did not express what remedies are available. That has been a decision for the courts. The legislature could amend the statute to expressly allow the remedy of exclusion of evidence for a knock and announce violation. But absent that, they basically said, we just want to protect the sanctity of the home.
I understand what I don't think you answered my question. My question was, we came out with Benefeld. Now it would be up to the legislature to then say, no, you got it wrong, Florida Supreme Court, which they certainly know how to. I mean, they do that often, and amend the statute. And that they haven't, and that means under some theories of case law that they have approved of our interpretation of this statute.
Well, you also have to look at how old Benefield is and how our society has changed. It's 1964 when Benefield was decided, and even 1968.
Well, that's a reason to maybe recede from it, but I gave you, I think you're in your rebuttal, so I don't want to have you use your last 40 seconds. Thank you.
All right. Mr. Fisher?
May it please the court, my name is John Fisher. I'm appearing on behalf of petitioner Kathy Jo Cable.
Can we start with the facts of this case and comparing it with the facts of Benefield? Because I'm somehow struck with the extreme circumstances.
Certainly it was extreme in Benefield.
I mean, it violated
there was just breaking in.
Let's not talk over one another.
I'm sorry.
Okay, we'll be better off that way. This extreme circumstances of in Benefield, forcible entry, no arrest warrant, no search warrant, no announcing, no waiting, etc. Here, do you agree that they announced it was sheriff's office? Please come to the door. He waited, then did not forcibly enter. He opened the door. It was unlocked, and according to him and what the trial court found, this defendant was asleep, which under our GM case, what would be the difference for her if he had said, sheriff's office, I'm here to serve a warrant? She's asleep, so she's not moving anyway. So how is it not like 180 degrees away from our 1964 opinion?
There were other persons there, and the son was awake. The husband was awakened by the police. Had the officer announced his purpose, they may have been more forceful to get her to come to the door in response to the officer announcing his purpose, that I'm here with an arrest warrant.
In terms of the actual statute, which is, although we say it's this, well, you look at it, it's not exactly a well-crafted statute. It basically looks like what is necessary, what an officer needs to do before making a forcible entry. So, and does it not protect those interests that the state said, which is preventing the law enforcement officer from suffering from any violence if they make an unannounced entry, preventing destruction of property, such as tearing down, what you see on these shows sometimes, the coming in and ransacking places, and protecting the dignity of those inside who might be, in states of undress. And it seems to me that those values are not, at least that's what Hudson said, are not the values that are served by the suppression of the evidence.
However, this court in Benefield said that it was enacting the common law by passing that statute, and it was to protect liberty and the sanctity of the home. Impliedly, I would say that's to protect privacy as well.
So
which
did
is
you make an argument that this should be that exclusion should be a remedy for the Florida constitutional protection of the privacy of its citizens?
Well, that's in the alternative to arguing that this court has crafted exclusion of evidence for violation of knock and announce, including solely just being the technical violation of failing to announce purpose. In our court, in their cases, there's many cases that evidence was excluded for failure to announce identification and or the purpose.
But those are all before Hudson. All the decisions were before Hudson.
And they were all based on the statute and not on the Fourth Amendment. The legislature is presumed to be aware of all of these opinions, and they have not amended the statute in the face of all these opinions that applied the remedy of exclusion for violations, even technical violations of knock and announce. If the legislature wanted to change that, they could have, but they haven't. They have presumably adopted the rulings of all the courts that exclusion is the remedy for violation of knock and announce statutes.
That's your best. Frankly, I think that's your best argument, that Benefield's been the law since 1964, that this court is not required by any of the circumstances that have occurred since Benefield to recede from it. That's,
Yes.
But otherwise, other than that, if we were deciding it on a clean slate, I think you'd have, let me ask you this, if Benefield hadn't come out and you were arguing this for the first time, in light of Jenkins, Hudson, and other cases, do you think you could make the same argument?
I could not make this on Fourth Amendment grounds in face of Hudson. That's clear.
But how could you make it on the basis of a judicial exclusion of a remedy if we, in Jenkins said that we are not going to create the remedy of exclusion for statutory violations?
But now, this creation of remedy is something that's been standing for decades, and the legislature has adopted this by failing to address it. If they didn't like it, they would have changed it. They certainly know how.
And the statute in Jenkins also made reference to civil remedies and injunctions and remedies itself. The statute is different than this.
I would say that the judicially created remedies are part of the statute until the legislature acts to remove it. And I would say that our constitutional right to privacy should have some effect. And what's more private than being asleep in your own home? The second DCA back in Robinson noted that unless the knock and announce statute is identical in wording to the Fourth Amendment, there can be state grounds for suppression rather than Fourth Amendment grounds. In Slaney, which was interpreting an implied consent law for a blood draw, they found there was no Fourth Amendment violation in the police lying to the guy to get him to consent to a blood draw. That violated the Fourth Amendment, but it violated the statute. In violation of a state statute, exclusion of evidence can be, and in that case was the remedy.
What's your take on an argument that there's a distinction between common law remedies and the Fourth Amendment remedy of exclusion? Is that more just words to say words, or is that really a meaningful distinction? Is there such a real distinction, or is that just something to say?
I'm not sure exactly how, if I exactly got this, but yes.
Okay. There has some discussed the question as to whether there's some concept of common law that would lead to the exclusion separate and apart from a pure constitutional basis. And my question is, we certainly know that there's a constitutional Fourth Amendment basis, but is there a difference? Is there a real difference, or is that just something to say?
Well, I think there's a real difference, and Benefield itself was applying exclusion as interpreting the knock and announce statute in light of the common law. And until our statutes or our cases are saying different, well, our cases are common law, but until our statutes say differently, we do apply the common law. And the common law of exclusion of evidence for violation of your rights in the absence of statute saying otherwise is something this case would follow other cases. And that's what we're asking for you to do here, is to affirm the second DCA's opinion that it had to follow the cases that followed Benefield. Benefield was an egregious case of violation, but in its progeny, there have been cases that have been as technical as this one and applied suppression of evidence as a remedy.
So you would say, so your argument again is, even if it's technical, its exclusion is the proper remedy.
Absolutely.
But under the circumstances of this case, who is really benefiting from the suppression of the evidence here? No one would. She was not even aware, even if the officer had said, "I have a search warrant," or arrest warrant, I guess it was. She would not have been aware of that. So what real benefit are we serving by suppressing the evidence here?
What happened was the officer saw her car in the parking lot, checked it out, saw that she was registered there, saw a teenager, approached the teenager. He said, "Yes, I'm her son." He says, "Go wake her up." He went in, didn't come back out. He didn't tell the son that he had an arrest warrant that he wanted to serve. He came to the door. He announced who he was. He didn't announce his purpose. Apparently, the father or stepfather of the kid, my client's husband, jumped up when the officer knocked and announced his purpose. There also was a couple other kids there. One was a friend, one was a brother of the teenager. Had the officer announced his purpose, this could have been dealt with without even the officer entering that home.
Didn't he twice say, twice knocked and said, I'm with the sheriff's office? That happened like in a couple of times, and no one responded at all, correct?
Correct.
Even though you say your client's husband and others were in fact present and heard the officer?
Well, that was according to the son's testimony. We had two witnesses, the police officer and one of the sons.
So if the son or the father had said, what are you doing here? So-and-so's sleeping. And then he said, I just want to talk. I mean, then he'd be actually being deceptive. But then it never happened. I mean, they didn't respond at all.
Well, the statute doesn't apply to saying that the occupants have to ask the officer's purpose. It says the officer has to announce his purpose.
Did this hotel room have a back door?
Not to my knowledge. I've never been in a motel room that had a back door, but part of the office, the state was arguing exigencies at the hearing, and the officer said part of why he entered was because he didn't want her to escape a back door.
Yeah,
Not that there was a back door, but there could have been a back door.
Yeah, I was going to ask you about that. In Benefeld, not only do we interpret a statute, but we actually then provide exceptions that aren't even in the statute. So
Correct.
We have essentially, by creating these exceptions, rewritten the statute.
Yeah, there are exigencies to this statute that were created
by
the courts.
By the court. So as far as saying that we are not going to exclude evidence for what we consider to be under the circumstances, not substantial violations, there would be no reason for us not to be able to do that because there's no guidance from the legislature anyway. Correct?
Yes. Well, basically here I want you to affirm the Second District Court of Appeal on independent state grounds based on the statute and additionally or in the alternative based on the constitutional right to privacy. Do you all have any further questions? Thank you.
Ms. Dunleavy, short rebuttal.
Actually, I have a question which may take up your rebuttal, but I neglected to ask it before. You've said that not announcing the purpose is technical, but if he had no arrest warrant and they're in a home or a hotel and police say it's police, I'd like to talk to you. Is there any law that requires a citizen to come to the door and open the door?
No, Your Honor.
So
if it were basically a knock and talk situation, no.
So
there's
unless they know that there is an arrest warrant, they have no obligation to come to the door to begin with.
That's true.
So it's really not, I guess, from my point of view, it's not really we've been calling it technical, or you have. I'm not sure. It may still be substantial compliance with the statute, but it certainly can't be considered a technical violation.
Well, what the deputy said, I believe, was something like he announced, deputy so-and-so or sheriff's office, come to the door. So he wasn't misleading at that point. Briefly,
so if the door had been locked, this door, he just turned the knob and the door was open. So, in the situation posited by Justice Carriente, where there was no arrest warrant, what could the police officer have done from there? You tried the door and the door was incorrect. Was locked. Could he,
if he didn't have an
use his
arrest
shoulder on it?
If he didn't have an arrest warrant under the facts we have here, then he wouldn't have a right to enter at all, because he didn't have probable cause independent of the arrest warrant, number one. Number two, what he would have done if the door had been locked, I don't know, and I really am not in a position to speculate. Regarding the back door, the deputy lives in that area. This is in Lake Wales, so he may have known that this motel did have back doors. I do have a colleague who says that she has seen motels that do, in fact, have back doors. So I don't think we can rule out the possibility that there was a back door in the absence of any testimony to the contrary. Regarding the right of privacy, that is not, our constitutional right to privacy is limited by other provisions of our state constitution, which includes Section 12 on searches and seizures. So no, with regard to search and seizure issues, our constitutional right to privacy does not allow any greater protections than the United States Constitution, Fourth Amendment, as interpreted by the United States Supreme Court.
And with that, thank you very much. Thank you both for your arguments. The court will now be in recess until tomorrow morning.
Please rise. Request now adjourned.
Now we can go home and watch ourselves on TV.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.